Good morning and welcome to the District of Columbia Court of Appeals. We have 3 cases on our calendar this morning. The first case is 24 CV 1163 DTLD LLC et al. Versus Power Station Limited Partnership et al. And the second case, it is consolidated with 24 CV 1173 JPMORGAN Chase Bank National Association versus DTLD LLC et al. That is hard to say, so I'm proud of myself that I got it out. Counsel, I think that you are remote. Can you hear us?
Yes, good morning, Your Honors. I can hear you perfectly.
Great. Whenever you're ready, if you could introduce yourself for the record and let us know how much time you'd like for rebuttal.
Thank you. May it please the court. My name is James Bacon, and I represent appellants DTLD LLC and Heraklion LLC. With the court's permission, I would like to reserve 3 minutes for rebuttal. This appeal, Your Honors, involves an issue that I don't believe this court has yet weighed in on, and that is the standard of review to a perpetual restrictive covenant on land. The trial court below did not apply the correct standard of review for this perpetual restrictive covenant. The trial court
counsel, do you mean standard of review? I usually think of standard of review as in, what's our review sort of, is it de novo? Is it abuse of discretion? Are you talking about what the test is?
Yes, Your Honor.
Analyzing restrictive covenants? Okay.
Yes, the test, the test that the court should consider in determining whether a perpetual restrictive covenant should be enforced. And we believe the trial court incorrectly applied what has been referred to as the radical change, otherwise known as the touch and concern test.
Could we be a little bit more precise? Because I think at the outset, I think our court has been pretty clear about saying, look, we understand restrictive covenants to be, in the nature of a contract, and we analyze them under contract principles, but then we do allow certain equitable challenges to be raised to those contractual agreements. Is that fair?
Yes, that is a fair analysis.
What is lacking in clarity is what are the nature of the equitable challenges, excuse me. What are the nature of the equitable challenges that can be raised to an otherwise binding contractual agreement?
Correct. And the analysis for perpetual restrictive covenants, because this court has a history and a background of disfavoring these kinds of restrictions, as well as providing equitable.
Is that quite right? I mean, if we're starting from the premise of, look, we generally look at these as if they're contracts. And so, if it's a binding contract, it's a binding contract unless you can come forward with some pretty powerful equitable reason to disregard the contract.
That's correct. But the test has to be what we assert is the reasonableness test and not the radical change test. That's the lens that this court should adopt and consider in light of the current conditions and circumstances of the commercial environment that we find ourselves in.
And why should we reach out to New Jersey to adopt this reasonableness test that you're inviting us to embrace? And really, what's the difference between the New Jersey test and the radical change doctrine? I mean, isn't that just another way of saying, well, if circumstances have so significantly changed, then it's unreasonable to have this restriction?
Well, the reasonableness test considers the enforceability of the covenant in view of the realities of today's commercial world, instead of what we believe are outmoded theories developed in a vastly different commercial environment. The District of Columbia is a megalopolis. The Maryland case
It's
that
so
was
nice of you to say that about us.
the Maryland case and the other cases that use the radical change test came from scenarios where there were open space, agricultural to rural, and then has changed over time to the urban and the city scenario. The district is unique because it has never been in that environment. It has always been
But
a city.
why does that matter? I mean, sure, I mean, I think at one point in time, the district probably did have some farmland within it's not quite diamond, but I just don't understand why that matters. There are certain areas of the city that are devoted to certain enterprises or almost exclusively residential. And there's other areas, and we're talking about an area that is, 3 blocks from the White House. So why I'm not quite understanding what the origins of the test, why that matters to its application here, even if we were to agree with you.
Well, we submit that it's better suited because of the fact that we're talking about a city. We're talking about conforming use, and the test, the radical change test, doesn't necessarily address the difference between eliminating or restricting a conforming use versus a non-conforming use. So,
but if we just had a conforming use test, wouldn't that undermine our basic premise that we generally hold people to their contracts when they've entered into them knowingly, intelligently, and voluntarily, right? Like, you can't have the equitable challenge be too broad. Otherwise, then what's the value of the contract?
Well, I would say this in response. If that were true, if that is the case, then the historical uses of restrictive covenants, which served as stalking horses for things like racial repression, segregated housing, those were.
Well, we have separate
Yeah.
public policy justifications for declining to enforce restrictive covenants, and I don't think you're invoking any of those here, right?
Right, but we're asking the court to consider a better test. The test is more inclusive. It allows you to consider parts of the radical change test in light of the current economic circumstances, which we provided evidence that have dramatically changed since when this occurred. And with the trial court below focused on one particular issue, and that is I'll use this term, lay of the land, or the egress and ingress for this particular property, finding that because of that terrible tragedy, which, by the way, the court in that case found the cause was the improper or inadequate security, the inadequate monitoring, which caused that problem that led to the decision to come up with this restrictive covenant, when there were a host of other factors that were involved in that case. And the trial court glommed on to that one particular issue and said that is the reason why we are not going to consider your issues, because that property has not changed. It has been the same, notwithstanding all of the host of other changes that we provided. The zoning density.
So what difference does it really make? I mean, if the restrictive covenant here had been put into the deed on the basis that the seller of the property just didn't like nightclubs, we don't have to worry about the alleyway or safety, just didn't like the idea of nightclubs. Are you saying that courts can come in and say that because the economic conditions of the surrounding area have changed over 30 years that we can and should just undo that restrictive covenant?
We're not saying you should, but what we're saying is you should review the current economic and commercial circumstances to determine what's going on with that property. In this case, 36 licensed establishments sell alcohol, including 8 nightclubs within a few hundred feet of this property. That is a very important fact that was disregarded by the court. The closest residential building has a restaurant on the ground floor. The neighborhood crime rate has completely changed and gone down. The drug issue has gone down. It's one of the safest neighborhoods in the city. These are facts that were presented that we believe raise disputed issues of tribal fact that the court ignored. And we're asking, Your Honor, under either test, whether it's the radical change or the reasonableness test, gives rise to our opportunity to present evidence and to reverse the summary judgment that was granted. Notwithstanding that, there is the ABC or the ABCA, which I'll refer to as the ABC ruling, that went through a whole analysis of the new changes.
The ABC had zero jurisdiction to evaluate the legitimacy of the restrictive covenant. And if I'm correct, that they said so. They said, we're not going to opine about that because that's outside of our purview as an agency. We're just here to decide whether or not you've met the criteria to get a license to serve alcohol, right?
But yes, but our position is that is a fact that was.
What is a fact? That they gave them a license?
The facts that were provided there were, among other things, that the proposed nightclub had a sufficient plan in place to mitigate any potential impacts.
No, that their review was not directed to the analysis that the Superior Court did or that you're asking us to review now. Their review was just to determine whether or not this entity could get a liquor license, right? And to the extent that they said anything that seems to indicate that the restrictive covenant shouldn't be enforced, I mean, they just had no business saying that because that's well beyond their jurisdiction.
I understand.
Go ahead, finish your answer. I'm sorry.
I was just pointing out that there were facts that the appellants had raised there that were consistent with the facts that we raised to this court that for whatever reason were not addressed and not analyzed and were simply, in our view, ignored. And we believe that to be error.
Does the reasonableness test that you advocate entail looking at the other possible uses of a property? I was thinking about this because, you mentioned that in the area, there are other nightclubs, and that's a factor that it seems under the reasonableness test could cut both ways. I mean, someone could think that there's no particular reason why this perpetual restrictive covenant is unreasonable because nightclubs can exist in the area. No one is deprived of a nightclub in the area. I mean, your point is it should not be enforced. The covenant should not be enforced because, oh heck, there are other nightclubs. We might as well let one in here too. But doesn't it cut just as well the other way? And in any event, isn't the availability of other uses of the property a relevant factor, even under your reasonableness test?
That would be true, Your Honor. What we're saying is the reasonable test is best because it allows the court to balance and weigh all of these factors in making its decision. And
would it lead to a different result here? I mean, it seems to me that it would lead to exactly the same result.
Well,
why is that wrong?
I think it would lead to the result that we have raised tribal issues of fact that should give us the right to be heard, as opposed to what this court did was to hone in on one particular fact and say that was the cause that and has never changed. That is your lack of egress and ingress. And based on the We Club case, I believe that was error because the court did not consider or articulate its factors for making its decision. It focused on the one issue there about the fact that this property has an indirect access to a public street and made its decision based upon that. And that is the big error that we're asserting was that should cause the court to reverse and at a minimum, give us the opportunity to present our facts.
Thank you, counsel. We will give you a few minutes in rebuttal and we'll hear from appellees now.
Thank you.
Failed to ask what the order of argument would be. I'm assuming that you'll just go one
I
after
believe
the
it would
other.
me, and then JPMorgan's counsel.
And you're going to split your time?
So I actually do not need to weigh in on the appellee side of this. We joined their brief, so I'm certainly glad to defer to him and just handle our intervention during our.
Thank you.
Well, good morning, Your Honors. My name is Eric Lammers. I am counsel for the appellees, the Power Station Limited Partnership, Southern Building Associates LLP, 15th and 8th Street Associates LLP, and SJG Properties LLC. Essentially all of them except for JPMorgan. I think the question before the court is whether a valid restrictive covenant, duly recorded, which was fully disclosed at the auction at which the appellants purchased their property, which they've admitted that they were fully aware of, that unambiguously precludes the use that they want to make of this property, should be cast aside so that a company can shoehorn an expansive, what they call a Vegas-style nightclub into an alley with no direct access to any main road, just blocks from the White House.
But what's the test, right? I mean, because a number of the factors that you recited just at the start seem to sound in the contractual analysis. And correct me if I'm wrong, you agree that that can't be the end of the discussion with respect to restrictive covenants,
So here,
right?
what,
I mean, for example, hypothetically, right? I could purchase property, it could be clear that there is a restrictive racial covenant in the contract for sale. I am on notice of it. It is clear, it is obvious, it is recorded. And then I could say, that's against public policy. So I don't have to, that restrictive covenant should be rejected, right? Like that would be okay.
so I think DC law is actually pretty clear that DC law treats restrictive covenants as contracts. It enforces them if they're unambiguous. It does have some equitable exceptions. So one is public policy. This court's not going to enforce a restrictive covenant which is against public policy.
And that's my hypothetical, right?
The other-
So you agree with me that the contractual analysis can't be the end of the story necessarily, right?
I agree.
There is some sort of equitable challenge, and we're talking about what the scope of the equitable challenge is. Nobody seems to be invoking the public policy line of thinking in this case. So the question is, what else is there? And radical change seems to have been where the parties were talking in Superior Court and talking about whether or not this New Jersey reasonableness test should be, although it's not even a reasonableness test, like it's just reasonableness is one component under New Jersey's test. Am I right?
Yes, I don't know what appellants are talking about when they talk about a reasonableness test. If you actually look at the Davidson Brothers test in New Jersey, it uses the word reasonableness, but it then has the court apply 8 factors. Those 8 factors are largely the same things that Judge Rust looked at here.
Okay, but sorry, just to back up. So your answer is yes. Correct me if I'm wrong. Your answer is yes, that there is a question to be asked, even assuming this restrictive covenant was freely and openly contracted to, recorded, and DTLD had actual and constructive notice of it. There's still a question to be asked about enforceability
I
as an
believe,
equitable matter?
yes, I believe that there are some equitable exceptions where the court has refused to enforce restrictive covenants. One is public policy. That's probably the biggest one. In some cases, courts have looked at estoppel or waiver, not applicable here. The one that was raised here, and I should note that it was actually raised by appellants, is appellants said that the equitable doctrine, the neighborhood change doctrine, or the radical change doctrine applied to invalidate the restrictive covenant here. That was their claim. So that's what Judge Ross dealt with, because they said that had been adopted as DC common law. It
Okay,
is
so putting
clearly the law
aside,
in Maryland.
putting aside whether they can change horses before appeal, and I'm not sure you clearly argued in your brief that they, some sort of waiver or forfeiture concept, but putting that aside for a moment, you would agree then, are you just proceeding on the assumption that we should then go down that path? Or are you agreeing that that would be the appropriate inquiry at that point, once someone has basically made that equitable defense to an otherwise validly enforceable restrictive covenant?
I believe Judge Ross said that this court had not actually adopted the radical change or change of neighborhood doctrine.
But there has to be
expressly.
some.
But there has been some courts applying DC.
No, but there has to be
law.
some inquiry at that point, right? Is my question. Are you agreeing with that?
We did not deny that there was,
Okay.
there should be an inquiry into whether or not the radical change doctrine applied. And I think Judge Ross looked at it, and I think he correctly applied it. In this case, I don't think there's much question that the radical change doctrine does not invalidate the covenant. And I think that's why the appellants switched horses midstream and tried to essentially invent a new standard, a reasonable test with no guardrails or guidelines.
So even with the radical change test, the question is radical change to what, right? And the covenant itself, the terms of it do not explain its purpose, do not explain the reasoning behind it. And that came from testimony, deposition testimony, I understand.
Well, I do think we actually provided testimony regarding why the restrictive covenant was put into place.
No,
And I
that's what
think
I'm
it's
saying.
really-
It came, right, but it's not in the terms of the restrictive covenant itself. It's not in the reason for institute or imposing this restrictive covenant do not appear in the language of the restrictive covenant itself.
No, well, maybe not expressly. Maybe they don't
Right.
say our purpose in doing this is to prevent a nightclub from being opened in an alley, but I think it's pretty clear.
Well, I don't know if it's clear from the language of the restrictive covenant. It may have been, but it came out in testimony, as you just said.
Right.
But other things came out in testimony as well, I think, unless you disagree with me. The witness spoke more generally of the economic interests of the surrounding properties.
I would agree that if you're looking at the impact, I think that was really in response to basically arguments that are raised by the other side. So in other words, the appellants have raised any number of social and economic factors as to why the neighborhood has changed in some way, that the restrictive covenant is unfair. And I think we did respond to those. So, you know, in response to those issues raised by the appellants, we certainly probably addressed that.
I guess
I don't know that that's really controlling on the question before this court.
I guess my question is broader, which is that if the purpose behind the restrictive covenant is relevant to its enforceability as an equitable matter, and the purpose behind the restrictive covenant comes forward in evidence, then why is it not then a fact question that's not really appropriate, at least in this case, for summary judgment resolution?
I think there was no real dispute about the purpose of the restrictive covenant or its effect. So I don't think there's really a summary judgment issue there to be had. I don't think there was any contrary evidence presented. I don't think there's a real question there, in other words. And if you were to send it back for trial, basically, I think it would be the same thing as is already in the summary judgment record, which is there was a club, there was a nightclub at this property. There was an act of violence. And in fact, I mean, if you look at the decision in the Novak case, they talked about there's testimony about fights routinely occurring in the alleyways. You know, we had a witness who actually was, you know, aware of that as one of the.
I mean, do we look past do we look at the sort of reasonableness of that justification at any level? I mean, in other words, let's say that what prompted the restrictive covenant was a safety concern, that, you know, following a horrific fight, the individuals involved in the fight were all wearing green shirts. So the restrictive covenant says you can, if you have a nightclub open here, you can't let anyone in with green shirts. And that's based on sort of a valid safety concern that resulted from, you know, that was prompted by this fight that happened some years ago. It's a crazy hypothetical, but my question is, you know, I'm not sure I see how much an alley necessarily plays a role in the safety concern here. I can see it, but I don't see it as clear as day. Or I'm just asking if we're able to look behind that at any level.
I don't think under the doctrines this court could apply that that's really something that needs to be delved into. I mean, I don't think the court simply looks amorphously at a question of reasonableness, because if you did, I mean, every restrictive covenant would be potentially be subject to constant litigation. I think you need to have guidelines and guardrails. And I think, you know, if you look at the radical change test and what the Judge Ross did here, I think that's absolutely correct. I mean, if the court does in fact adopt the radical change doctrine.
Counsel, how would you describe the guidelines that are imposed by the radical change doctrine then?
The court looks at whether the neighborhood, the surrounding area has changed so radically that the purpose of the restrictive covenant no longer serves a purpose.
But what's the neighborhood and what's the level of radicalness? And I mean, here there is testimony in the record that the broader neighborhood has changed quite a bit in the past 20 years, right? But
Disagree that there's admissible evidence regarding the changes in the neighborhood. Okay, I mean, neighborhoods change, yes. But how this neighborhood has changed in any way that's relevant to this restrictive covenant, I'm at a loss to say. So is it safer? Is it less safe? What's the admissible evidence on that? I mean, basically appellants rely on anecdotal evidence. They say there's been one police call relating to this property in 2023 and related to a stolen vehicle. Is that more crime or less than was before?
See,
Given that the property was vacant, I don't know how there was even one stolen vehicle.
You seem to be making arguments now that would support the fact that the notion that this should have gone to a jury, when I thought your argument was it's not really radical change about the whole surrounding neighborhood and the economic circumstances and the like, but it's that this building still opens only on this alley, only has ingress and egress to this alley, and that hasn't changed.
That's correct.
And that's the end of the story for you.
Essentially, yes, those are the conditions under which the restrictive covenant was imposed. Those conditions have not changed.
So you seem to be saying that the radical change test should only pertain to the particular conditions that prompted the restrictive covenant at issue.
Yes, I mean, in the very least, I'm not aware of a court anywhere in the country that has looked at a change in crime rate. I'm not aware of a court anywhere in the country, including in New Jersey, that has looked at fluctuating economic conditions or the Doge cuts or any of these other things that are transient and that change over time. I think what they're looking for are permanent changes in the physical neighborhood. In this case, which I think is defined as square 220 in the restrictive covenant. So, I've only got 2 minutes left here. Let me think. I want to talk just a little bit about the reasonableness test. So let's say they only have 2 cases in support of what they call the reasonable test. One is a West Virginia case. I think it's Mraz. And they quoted as saying, there's this question of reasonableness. If you continue to read the case, the next line is that a restrictive covenant is reasonable if it's not against public policy and doesn't create a monopoly. Because that case was primarily concerned with non-competition covenants. Davidson Brothers also is a non-competition covenant case. And what Davidson Brothers does is they review basically the same factors that Judge Ross reviewed here. It wasn't this wide-ranging exploration of economic conditions or livability or whether or not there are more youth in the neighborhood that are clamoring for more entertainment. And the only other statement I'll make here is that appellants have made much that there are other nightclubs in the area. And I think you can quibble about the size or whatever about that nightclubs, but the fact is none of those nightclubs are in an alley. There's nothing preventing appellants from purchasing or leasing another property in the neighborhood and opening a nightclub, you know, even a Vegas style nightclub. There's no reason they have to do it in an alley.
Can I ask you what you would have us do, whether or not we affirm or send this back? But do we need to announce what the inquiry is with regard to an equitable challenge to an otherwise valid and enforceable restrictive covenant?
Are you asking whether you need to adopt the radical change doctrine expressly or not? Is that the
Yes.
question?
I get
In my
that, yeah.
opinion, no. I mean, if Judge Ross got it right, he considered it. If it does apply, it doesn't apply in this case.
But I mean, he adopted it and considered it and applied it, but because our law already dictates that, or, I mean,
I think he viewed it as adopted as DC common law because it's part of the law of Maryland. Whether this court actually needs to do that, I would submit no. I mean, the doctrine clearly doesn't apply. So in my opinion, the court would not need to effectively adopt that doctrine in order to reject it because it doesn't apply and therefore it doesn't matter. But it's a question for the court. Thank you, Your Honors.
Thank you, counsel.
Yes, Your Honor. Thank you.
I'm sorry, we're gonna hear briefly, yes, or no, you don't feel a need to speak, and that's fine too. Thank you. Okay, yes, Mr. Bacon, we'll hear from you in rebuttal.
Thank you, Your Honor. Let me start first with the switching horses comment. I think our brief and our arguments below in the trial court were that the facts have changed so radically from 1998 to where we are now. That's different than saying we adopt the radical change test. What we said was, look at all the facts that have radically changed. And I think there's a difference there between our facts being so different and radically different than what we found in 1998. Secondly, under either test, radical change or the reasonableness test, which I submit this court should announce. It has not previously passed on this issue, and this is the opportunity for DC to announce this test. And we submit under either test that we have raised triable issues of fact. We would ask the court to endorse the reasonableness test, but either way, we believe we have raised facts that are triable and we should have the right to try them. The last thing, again, what the judge did below was rely upon the We Club case. The We Club case, if you read it, stood for the proposition, I submit, that when you do not have security, you do not have monitors, you do not have security people in or out, you do not have lighting, you are going to give cause to the kind of tragic event that happened here. Not as Your Honor indicated about the fact that there's an alleyway that leads to the public street. That's not, as the trial court below found, the cause, the proximate cause for the problem in that case. The cause for the problem in that case were all these other deficiencies in security. And for the trial court below to find that that was the reason, and the only reason, I believe, is error. And as a result, we'd ask the court to reverse.
What are the triable issues of fact that you think need to be resolved in a trial? What are they? Give me a list, as many as you can tick off the top of your head.
Well, so depending on, we have provided evidence that the location is high density, mixed use. There are 36 other establishments. There's 8 nightclubs. There's a restaurant right across.
What's the issue, though? What's the triable issue of fact? Is it, has the neighborhood changed? What's the issue?
Correct. Yeah. In other words, the change, whether it's radical or a balancing, is a change in what's going on with that neighborhood. We provided the change and it was just completely ignored and disregarded.
Okay, what else? You said there were triable issues of fact. One is, has the neighborhood changed? What's the next one?
Are there other establishments that sell alcohol? Are there other nightclubs? Are there, what's the crime rate? Are there other locations in the neighborhood where they can provide this kind of nightclub that we propose that conforms to the urban character of the neighborhood and the downtown? So I think those are all issues that we have raised that were not addressed in any form of analysis by the trial court below.
I thought that Power Station Unlimited said that none of those facts mattered. Right? I mean, they'd say, so what, right? That the building hasn't changed. That the location of the building hasn't changed. The egress in and out of the building hasn't changed. That's the important fact. And there's no dispute of fact as to that.
Well,
so doesn't this turn on sort of what we say the legal test is then? Because if the test is, oh, you get to look at crime rates and changes in the neighborhood and, you know, the effects of COVID, then sure, you guys can duke that out in trial court, but we have to figure out whether any of that matters first.
I would agree with that. Yes.
What's your best case to say that we would look at any of those things? Because Power Station Limited Partnership says that they can't find any cases where courts have looked at those things.
Well, I think the cases we cited, the Davidson case cited a Pearson versus DMH2 Laboratory Liability Company, which is also a New Jersey 2016 case, was one of the cases where they looked at those kind of facts that we've argued for the court reviewing in this matter.
All right, thank you, counsel. Okay, sorry. Now, Ms. Farmer, if you would like to take to the podium for your separate issue.
Your honors, may it please the court, and I will reserve 2 minutes, let's say, but I expect to be very brief. We obviously join in the argument of the appellees for the prior. The one note I would make is that this all stems from the summary judgment papers filed by the defendants in the lower court. JPMORGAN has filed this appeal essentially as a precautionary matter in the event of remand, that they would be allowed to participate in these inquiries if they proceeded.
Right, and I guess I don't quite understand, right? If we were to affirm, then your motion to intervene is really moot. And if we were to reverse, you have a trial judge ruling saying your motion to intervene is moot because it's denying relief, or it's giving you any relief you might wish for. But if we reversed that, then everything is opened back up again, and presumably you could renew your motion to intervene and the trial judge would rule on it, but we don't have a ruling right now from the trial judge on your motion to intervene. I don't see why we would say that the trial judge did anything wrong, which is what usually appeals are for.
Understood, and I agree with your presentation. I think the issue is that there is a lack of clarity under DC law, whether in the event of remand, we would be able to file a new motion, or if by virtue of not appealing, that would have been deemed waived. And so we did not want to have any risk of saying we did not challenge that order and rendering it moot, so that assuming, just for the sake of argument, that this were to get remanded, so that the defendants couldn't say, you're actually not allowed to do this again because you didn't appeal. And so it was no longer preserved and you are not a party to this case.
Where does that lack of clarity come from?
So we have been unable to find a specific case that is directly on point that would say you can file a second motion, probably just because it hasn't been appealed. There are certainly cases where this court has reviewed where a motion to intervene has been denied as moot and indicated something in response. So it really, truly was wholly precautionary.
Okay, but there are no cases out there that say if you don't appeal, you've lost your chance to, I mean, it just seems like obviously a changed circumstances situation where you would be able to communicate to the trial court and say, we can renew our motion, or we can refile. Which would you prefer? Right?
I wholly agree. And
Okay.
assuming that is the way this court feels, I'm certainly glad to cede the rest of my time.
I'm just trying to clarify whether
Yes.
there's some sort of impediment to that, whether we have said something that unintentionally would suggest that you didn't have either of those avenues available to you unless you come to us.
I think it's just the lack of there being anything directly on point that led us to this. We had requested intervention. Obviously, we are pleased with the result. We agree with the result of the lower court, given upholding the restrictive covenant. So it really, truly was a precautionary measure to avoid any claim of waiver, especially given how this case has proceeded. So I understand the court's position, and we certainly can move in the future if this case is to be remanded.
We were to remand, you would like it if we said something like, and of course, JPMORGAN should be permitted to file a motion to intervene. You would like that?
We would appreciate that. However, understand, we would defer to the court on that issue. We do, I will say, I think it was fair for us to expect, given the controversies in the case, that it would be disputed on remand and there would be motions practice around it. So it was essentially trying to get ahead of that issue. But if the court does not have questions, I can cede back my time and rest on our briefs.
Thank you very much.
Thank you.
Mr. Bacon, would you like to respond?
I don't have much, Your Honor. I agree with your position. The only thing that I would raise is JPMORGAN has never explained why it did not know of its interest from the time the complaint was filed in November.
That goes to the merits, Mr. Bacon, right?
Right. So I don't have
So
anything.
do I hear that there's a concession from you that were we to remand, that JPMORGAN could file a motion or could renew its motion to intervene, at which point the merits of their ability to intervene could be litigated?
Yes, Your Honor.
Thank
So
you.
conceded.
All right. The cases will now be submitted, and we thank counsel for your arguments today.
Thank you, Your Honor.
The next case on our calendar is 24 CV 1187, Estate of Barry Michael Pearson et al. Versus MedStar Washington Hospital Center et al. Counsel, when you're ready, you can come to the podium and introduce yourself and let us know how much time you would like for rebuttal.
Good day, Your Honor. I represent Sylvia Pearson, a personal representative of the estate of Barry Michael Pearson, and my name is George Livingston Garrow Jr. Thank you.
Counsel, if you could keep your voice up a little bit, I'm
Yes,
having
sure.
a little trouble hearing you. Thank you.
This case must be reversed because the trial court misapplied DC law in two fundamental ways. First, it rejected res ipsa loquitur based on factual misunderstandings and legal error. Secondly, it excluded plaintiffs' experts, not for methodology, but because the trial court disagreed with their opinions. And if the appellants prevail on either of those issues, we'd ask that the case be remanded for a jury trial.
So that just starting with the second issue first, how do we know that the trial judge disagreed with the experts' opinions? I've read the 60-page hearing transcript more than once.
Yes.
I found it extremely difficult to follow. And I mean, my view is, for abuse of discretion review on the admissibility of expert testimony, if that were load bearing in this case,
I'm sorry, did you?
if that were load bearing in this case, if I had to say whether the judge abused his discretion in ruling that the expert testimony was inadmissible, I would have to remand because I have no idea why the court issued the order that it issued in 2 pages with no analysis.
Well, yeah,
So,
I'm sorry.
so my question is, I mean, I mean, you say it's error. It seems like I don't even know, right? Like, do you agree with that it's not clear what the judge was saying?
It was like a fire hose, and we did the best that we could as plaintiffs' appellants to determine what the judge was objecting to.
So
he-
let's, for the purpose of this argument, let's just assume that the expert testimony should have come in. Then the issue for me is, why did the expert testimony that the Pearsons, your clients, put before the court make it more probable than any other theory based on the evidence that Mr. Pearson's stage 4 pressure ulcer was the result of negligence? And to put so do you agree that's the showing that needs to be made, that you have to show that it is more probable that the pressure injury was the result of negligence? Do you agree with that?
That's the standard of care.
Okay.
Yes.
Well, that's not the standard of
Well,
care.
I mean,
right? We're not talking about standards of care anymore because we're in res ipsa land,
I understand.
which obviates any discussion of breach of standard of care. Right?
Yes.
It's because we can't prove a breach of standard of care that we're going to res ipsa.
Absolutely.
Okay. So, and you agree that the legal test for res ipsa is what I've just said? The
yeah.
more probable.
Yes, more probable than not, because the specific act of negligence is absent or hidden from the plaintiffs.
Well, it's because it's more probable that this injury wouldn't have appeared absent negligence, I think is how we've said it. Okay.
Yes.
So the defendants in this case, MedStar and Kaiser, put before the trial judge in the summary judgment motion and the motion to preclude the expert, an expert report from Dr. Osman. And Dr. Osman is board certified in internal medicine.
Yes, Your Honor.
And wound care. And he opines that the pressure injuries were unavoidable. And he details 9 reasons that the pressure ulcers couldn't heal and why they just kept deteriorating, right? And he ticks through all these health problems that Mr. Pearson had. You know, he had blood pressure problems, he had kidney problems, he had breathing problems, he had nutritional issues, and all of that. I can't recall off the top of my head, but the expert said these are all reasons that Mr. Pearson's skin would have deteriorated and why it wouldn't heal while he was in the hospital for 3 months. So that's an explanation as to why this wasn't negligent. What do you think your experts said in response to those 9 reasons? To say, no, those 9 reasons are not why Mr. Pearson developed pressure ulcers and why once he developed them, his skin wouldn't heal.
Well, Your Honor, there was no trial. So.
No,
this
no,
is
no,
not the-
I
this-
understand.
we're at the summary judgment.
I understand. You put in expert testimony, you put in expert reports, your experts were deposed, there were interrogatories.
Yes.
In those materials, right? Because those are the materials presumably that you put forward to say summary judgment should not be granted to the defendants. What do you think in those materials your experts said to respond to Dr. Osmond's expert opinion?
The consensus, Your Honor, in the medical community is that stage 4 pressure ulcer happening in a hospital-acquired pressure injury is avoidable.
Well,
If-
that's not actually true,
Well, Your
right?
Honor,
Like
yeah,
the CMS guidelines that your experts cited in their reports call these pressure injuries never events.
yes, Your Honor.
But that's actually kind of a misnomer because then if you actually read the guidelines, again, that your experts cited, it says some of these events are not always avoidable given the complexity of the healthcare. And once again, we have an expert from the defendants saying this was complex. I mean, that's why we have the experts in this case anyway, right? Because this was a complex situation, right? Mr. Pearson was in the hospital for 3 months. He was in the ICU. He went into the ICU 3 times.
Yes.
So again, I understand your experts said that this sort of baseline is categorized as a never event, but where did they actually respond to the expert that the defendants put on who said, look, this was not avoidable and couldn't heal for these 9 reasons?
Your Honor.
I just didn't see it anywhere. All I saw was sort of in a vacuum, these things shouldn't happen. But asterisks, even the materials that we say are authoritative and that we are citing on our reports say they can happen when it's complex, when someone is terminally ill or dying, when someone is, sorry, I'm going to get the hemodynamically
Hemodynamic
unstable, right? Like they acknowledge it can happen. And then there is an expert that says, yes, all of those things were going on and more. And I don't see any response from your experts saying, well, wait, that's not right.
Well, Your Honor, that's what the case is about. It's a test of the experts.
But my point is the experts seem to talk past each other, right? And I guess another question is your experts were wound care experts, right?
Yes, Your Honor.
So
This
they're not, Nurse Rodriguez is a part-time wound, ostomy, and continence consultant. And she says in her deposition, I'm not a medical professional. I'm not trained as a doctor. I can't make medical diagnoses. All she can speak to is wound care. Dr. Guerrero similarly says, look, I was board certified in surgery. I'm no longer, I 100% do wound care. And I can't I can't define what is hemodynamically unstable. I don't know about pulmonary fibrosis. I don't know about all of these comorbidities that Mr. Pearson had. And so they can't even respond to what Dr. Osmond says because they acknowledge they don't have the training to do that. So I don't even see a dispute of the experts because they are just saying, look, in a vacuum, this shouldn't happen. Although we acknowledge as authoritative these materials that say that it can happen. And then you've got an expert who is an expert not just in wound care, but in internal medicine saying, I'm looking at this patient. And this patient had so many health problems. And that's why he was in the hospital. And that's why he went into the ICU 3 times. And that's why he didn't sadly leave the hospital and died in the hospital. And this patient, these bed sores, these pressure ulcers were unavoidable. And there's reasons other than negligence that they would not heal. And I just don't see a response to that.
Well, Your Honor, every patient, well, most patients that come into the hospital and in nursing homes have comorbidities. That does not relieve the facility or
Sure,
the
there's
doctors.
a range. People can have a range of comorbidities. Where is it that your expert said someone with Mr. Pearson's comorbidities, which were significant, would not, that his pressure injuries still were avoidable?
They state that in the depositions, Your Honor, that
I don't think they stated that someone with his comorbidities. I think that they said people, generally people go to the hospital because they're sick. True. But I still don't see that as being responsive to Dr. Osmond's much more particularized testimony that is tailored to Mr. Pearson's health conditions and saying, look, for all of these reasons. I just don't see a response to it. And I guess what you're telling me is their general response was response enough.
I didn't, I guess I would take a bit of umbrage in saying that their responses in both of their reports and in their depositions were generalized. I mean, they reviewed all the materials with respect to his records with respect to Mr. Pearson, and they were extensive.
But
And they said,
but they didn't talk about them, I guess is my point. Like yes, they said that they reviewed them, but where in the expert report or in their deposition do they actually go through in any detail any of these comorbidities and talk about why, even though he had these comorbidities, and even though Dr. Osmond says that those comorbidities made these pressure ulcers unavoidable, why in fact they were avoidable even with these comorbidities?
I note that Dr. Guerrero is an internal medicine specialist.
No,
And he said, no, he is.
Can you show me that in the record? And I'll when you get up on rebuttal, but because I looked pretty carefully at his degrees and my recollection of the record, but feel free to correct me if I'm wrong when you sit down, is that he said that he was a general surgeon, that he gave up his board certification in general surgery 5 years prior, and that he was only certified, but not even clear whether it was a board certification in wound care, and he 100% did wound care. I don't recall him saying anything about him being an internal medicine doctor, but you can correct me if I'm wrong.
And I will look at it again, Your Honor, but it goes to the core of your argument, Your Honor. I don't think that when in Dr. Guerrero's expert report, he defined what the standard of care is for a patient, such
Right.
as Mr.
James,
Pearson,
I'm
who comes into the
cut you off just in the interest of time because, and this is making another point, his expert report was written before res ipsa came into the case.
It's true.
So his expert report was written to show breaches of the standard of care,
That's right.
which is not an issue again when you're in res ipsa territory, right? So that is what his expert report is written to, as is Nurse Rodriguez's, and that's what their deposition testimony related to, was breaches of standard of care. There's some general testimony that, you know, then could support a res ipsa defense of, look, this is a never event, this isn't supposed to happen. But the defendants respond to that, and they respond to that with particularity. And so that's when res ipsa sort of is litigated at the summary judgment stage. But these experts were never intended as res ipsa experts, I guess, is another, you know, do you agree with that? Like, they were not presented as res ipsa experts because, as you just conceded, res ipsa hadn't come into the case when they wrote their reports.
I do agree that they were not designated initially when res ipsa came into the case. I don't agree with respect to the court's statements that Dr. Guerrero's expert report is not applicable in the situation of res ipsa. I think
I'm
that
not saying it's not applicable. I'm just saying it's generally not terribly helpful, especially when you put it up against Dr. Osmond's report.
well, we still have the issue of causation, and I think he addresses that.
Well, let me get back to Judge Easterly's point about the experts talking past each other. Is there somewhere in the deposition testimony, perhaps, if not the expert reports, which I understand were written early on, is there somewhere where your experts said something to the effect of, I have seen many patients with comorbidities like Mr. Pearson's, and even in cases like that, I can tell you from my vantage point as a wound expert that this pressure ulcer was avoidable.
Dr.
Do
Guerrero,
they say something like that? Or is it the case that you can't find any in the record anywhere where they have addressed the possibility that in the case of a patient like Mr. Pearson with many comorbidities, a pressure ulcer might be unavoidable?
Dr. Guerrero was asked on his deposition with respect to comorbidities and Mr. Pearson's comorbidities. And what he said essentially is what I said before, which is patients present to hospitals and nursing homes, generally speaking. If we're talking about a seriously ill patient, they have comorbidities. That doesn't obviate the need for the hospital to develop a care plan and to address that patient's needs. So essentially, with respect to Mr. Pearson, what the experts are saying is whether it's Mr. Pearson with comorbidities or any other patient, you take a patient where you find them, and if that patient enters the hospital with no skin tears and over a period of time, 2.5 months, goes from no skin tears, September 19th, when he entered the hospital, to October 7th, developing stage 2 pressure ulcer, to December 10th, where he develops a stage 4 pressure ulcer and dies 2 weeks later. That is the responsibility of the hospital, because it clearly, the hospital, and in this case, Kaiser, because no skin offloading. That means, and this is what happened in this case, no skin offloading, no turning and repositioning.
Counsel, it sounds like you're talking about breaches of standard of care now, but I thought we were on res ipsa. And I just want to make sure that I understand what the hook is for the res ipsa, because I thought that the hook was stage 3 and stage 4 pressure ulcers are never events.
Yes.
Right? Okay, so
Okay.
you're talking about 2 weeks in, he has, well, actually, yeah, about 2 weeks
That's
in.
about 2 weeks,
He
yes.
has a stage 2
Yes.
pressure ulcer.
Mhm. Around
That's not a
October.
never, that's not a never event. Right, so
No.
the stage 2 pressure ulcer is not evidence of negligence, because that's not a never event. And that's discovered when he's in the ICU for the first time for the GI bleed, right? So, and that at that point, and so I just want to make clear, right? He doesn't have the stage 4, he never is diagnosed with a stage 3 pressure ulcer. Doesn't have the stage 4 pressure injury. It's not documented until December 17th.
About December 10th,
Which-
Your Honor, I believe.
I'm sorry?
I believe it was December 10th, but
Okay, I'll go back and check, but December 17th is the same day that the family is told that he's experiencing multi-organ failure. When they have a palliative care meeting and they say, you know, they've already been told that or it's already been annotated back in October that he's actively dying, but they're told on December 17th, so when I thought that the first stage 4 pressure injury is documented, that he's having multi-organ failure. So isn't that the time that we should be looking at to see whether there is evidence like that res ipsa applies, right?
It culminates there because that's, we can argue December 10th through December 17th, when it is documented that pressure ulcer is a stage 4 pressure ulcer.
Right.
But getting back to this issue
At
of.
that point, he's already been in the ICU 3 times, right?
Yes, Your Honor.
And
But-
and he's been determined to be actively dying, and they're talking about palliative care, and you know, so I'm not seeing where I didn't see where your experts sort of focused in on this. They said stage 3 and stage 4 was the never event, but they didn't focus on when stage 4 was actually diagnosed. They just were sort of saying generally he comes into the hospital without any issues, which isn't quite accurate because he did have other issues, and Nurse Rodriguez hadn't looked at his medical records from before he was admitted. But they say he comes into the hospital, he should have come out of the hospital without any pressure injuries. But that's not the res ipsa test. The res ipsa test has to be tied to the never events of the stage 3 and stage 4 pressure ulcers, right?
Yes, Your Honor, but I don't think that the court can avoid the fact of how, over a period of time, the pressure ulcer is created, and that it is in the control of the defendants. They have Kaiser and MedSTAR Washington Hospital Center have joint control over his care. So we're talking about can the elements of res ipsa be met? That's what we're really dealing with here. And,
Right. And the whole agency issue is secondary, right? You have to show res ipsa first.
Yes,
Okay.
we agree with that. And so with respect to the elements of res ipsa, our experts, using the literature that is cited in the appendix, state that ordinarily a stage 4 pressure ulcer, ordinarily stage 3 or stage 4, in this case stage 4, ordinarily does not occur in the absence of negligence. And that the consensus in the medical community, notwithstanding what I understand what Dr. Osmond said, but with respect to the consensus in the medical community. And if you look at appendix A527, where we talk about the National Pressure Ulcer Advisory Panel literature back 15 years ago, that conference was had because it generally is the case that a stage 4 pressure ulcer is avoidable, with the rare exception of what that conference was dealing with at that time, which was end of life pressure ulcer. And
Well,
pressure ulcer
that wasn't what it was only dealing with, right?
Well,
They were looking at when pressure ulcers could be avoidable
But
or
look at the
unavoidable.
first
and
paragraph,
it
Your Honor.
says- Well, I'm
First-
looking at the conclusion, and it says the panelists reached the consensus that unavoidable pressure ulcers may develop in patients who are hemodynamically unstable. That's Mr. Pearson. Terminally ill. That's Mr. Pearson.
active.
Have certain medical devices in place and are non-adherent with artificial nutrition or repositioning, right? So, I mean, he's got a medical, I don't know whether his feeding tube is a medical device. He certainly has nutritional problems because he's on a feeding tube. And you know, this is the general expert literature that your experts say is written by an entity that is authoritative. And then we've got the expert testimony applying it to the facts of this case, saying this patient had these 9 issues that led to unavoidable pressure injuries.
Your Honor, well, again, I would argue that if you look carefully, now that document, that conference paper was a long paper and it discussed a number of issues. These are professionals, so they're kicking issues back and forth. But if you look at the first paragraph of that document, it says, the purpose of that conference is we are now trying to determine whether or not a pressure ulcer in a narrow circumstance could be unavoidable. And the only pressure ulcer identified in the literature is inner life pressure ulcer, which occurs within hours, possibly 48 hours of a person's death. That's the only pressure ulcer.
I don't think that that article says anything about 48 hours. I think it
It
actually
does-
says within 6 weeks of death.
Well, Your Honor, I'll
I
look.
mean, I know that your experts opined
Instead-
to that.
Yes, and that's,
Your experts aren't internal medicine doctors. Your experts aren't experts in, treatment of, they're not cardiologists, they're not lung doctors, they're
But-
not kidney doctors, they're
but-
wound doctors.
but you're discounting, Your Honor, the fact that they, plaintiff's experts, day in and day out, deal with patients who have these issues.
Maybe, except they didn't say that they had seen someone like Mr. Pearson.
No, Your Honor, that's who they treat. And when asked in the depositions,
I'll let you when you sit down,
Look.
you'll look for Dr. Guerrera's qualifications. You can show me where they actually said that they saw someone with as many comorbidities as Mr. Pearson. I just didn't see it. I would, in the interest of time, like to move on to the informed consent issue.
oh, yes.
Unless you have anything else you'd like to say
no,
on the res ipsa issue.
Not at this time, Your Honor. With respect to informed consent, very quickly, Your Honor, what we're saying essentially is that a reasonable person would want to know the risk of developing a stage 4 pressure ulcer during months of immobilization.
When do you think that conversation should have happened?
It should have happened, he was in the hospital for a 3-month
I
period.
understand he
Yeah,
was in the
I
hospital for
understand.
3 months. I'm asking what day, when he was admitted? When should he have been told
Ideally,
there is a risk of developing serious pressure injuries from long-term hospitalization?
he should have been told that from the beginning.
So when he's admitted?
Yeah, absolutely.
When they don't know that he's actually going to be in the hospital for a long time, but they should have just told him that.
They may not have known that he would be in the hospital for 3 months, but they knew that he was going to be in the hospital and that for an extended period of time, and that during that time, he would be immobile or primarily immobile. Any patient during that initial admission and during the care planning process should be explained all of the risk of
But what would your clients and Mr. Pearson have done at that moment?
it may not have been the best option, but an option to go to after a short period of time in the hospital dealing with the specific issue he came in with. He could have gone to a subacute rehabilitation facility. Now, again, that may not have been the best choice, but it's the choice that the family and Mr. Pearson
So he
should
could-
have been advised
he should
and
have
they
been-
could have made.
He should have been told. I'm still not quite clear on what he should have been told. He should have been told when he showed up at the hospital having experienced a heart attack. You should know that if you spend time immobile in a hospital bed for any period of time, you might develop a pressure injury. At least a week or two, you might develop a pressure injury. Several months.
Well,
I'm not sure what they're supposed to be advising him of.
They should be advising, even if it's not upon admission, if he's been in the hospital for 2 months. I'm sorry, a couple of weeks. That process can be triggered again.
You're shifting the timeframe.
Well,
I
well,
thought you said that he needed to be told at the time of admission.
And that would
And
be our
is-
statement.
That's your position?
Yes, Your Honor.
Okay, so, I mean, do you have to tell people when they're going to be hospitalized about other dangers of hospitalization, right? Like, there are certain infections that you can acquire in the hospital, right? Like staph infections that just happen in hospitals. Do you think that we need to tell everybody, you should know if you get admitted to this hospital, you might get a staph infection?
If the hospital has a history of
No
the
history,
patients, no.
history, just like it's possible.
Your Honor, obviously, we're not asking a hospital to be an insurer to provide everything that could possibly happen to a patient. But if you've got a patient and that patient is going to spend a considerable period of time in the hospital, likely immobile, that patient has to be advised.
Then doesn't that directly, isn't that inconsistent with your res ipsa theory? Because your theory on res ipsa is this doesn't happen, this can't happen, this should not happen. That seems to undermine any notion that a hospital would warn someone. I mean, so you take your standard res ipsa situation
Yes.
in a medical malpractice case where courts have applied it. I know they do sparingly, but cut off the wrong limb, right? Amputate the wrong limb.
That's a never event, by the way.
Okay, right. And I mean, that could be, I'm not opining on that here because it's not before us, but that could be a res ipsa medical malpractice case, right? I mean, do hospitals warn patients that we might cut off the wrong limb? And get informed consent that you are accepting the risk that we might cut off the wrong limb? Or leave a sponge inside the surgical site?
In the informed consent document, they may have at the bottom a catch-all phrase that talks about the possibility that things that might happen to you that you didn't enter the hospital for. But with the specificity in this case, we're arguing that the hospital had a burden when there is a patient who is going to, or they reasonably believe is going to have an extended period of time, an extended hospitalization. That period, that what he really has to be warned of, what he has to be informed of is that there might be other options, even if those options are not the ones that they would recommend.
Is the evidence in this case that they knew that he was going to have an extended stay when he entered the hospital, having had a heart attack?
Well, he had been to that hospital previously. He entered and had end-stage renal failure. There was an issue with respect to them providing a dialysis while he was in the hospital.
But what's the evidence that they knew that he was going to have to stay?
Well, the fact that he entered the hospital with a heart attack and having end-stage renal failure.
Do you have an expert saying, or is there any notation in the medical record saying this gentleman's going to be here for a long time? Right? Because it seems like
That's not
just
required with respect to informed consent, but yes, Your Honor.
well, I guess I'm still not understanding what the risk is that they're supposed to be advising him of. Because if they don't know, right, how the situation is going to progress, and unfortunately in this case, it progressed in a direction that was unfortunate for Mr. Pearson, right? I mean, he's in the hospital and then he develops a GI bleed and he goes into the ICU. You know, do they know at that point that he's going to develop a GI bleed? I don't think there's any evidence that they knew that. He gets out of the ICU and then he has a stroke and he goes back into the ICU. Do they know that he's going to have the stroke? I don't think there's any evidence that they know that he's going to have the stroke. He, you know, is in the regular part of the hospital and then goes back into the ICU because something's happening with the tubes. sorry, I'm not speaking with any medical
I understand.
accuracy, my apologies.
Yes, sir.
But, it just seems like things happened, unexpected things happened. And so I'm still not understanding what, even if you're saying, okay, well, it's clear that he had to be warned at the outset, what is it that they're warning him of? At some point, it seems like what they're warning him of is so vague that it's kind of pointless of, you're gonna come into the hospital and things might not go well for you because sometimes things don't go well.
Your Honor, it's
And so
not,
you should just know that.
it's not a warning. It's informed consent so that the patient can make the decision that the patient believes is best for the patient.
Right, okay, and so let's assume then, okay, there was something that they could inform him of so he could make a decision, and your position as that the decision would have been to leave the hospital just to go to a different nursing care facility?
Well, the family could have made decision to have him stay in the hospital and be treated for his immediate conditions. And then go to a subacute rehabilitative facility.
Right,
Now,
and-
as a matter of fact, Your Honor,
it
that
happened.
was something that the family raised later in the process.
That had happened, is it a problem that Dr. Guerrero said that there's really kind of no difference in the risk of developing pressure ulcers between being hospitalized and being in a nursing facility? I mean, it seems like out of the frying pan into the fire, wherever
Your Honor,
he
it may-
is, he's gonna be in bed, because he's really sick.
Again, Your Honor, it's the issue of the family making a decision. It may not be the best decision, but it's the family's decision, it's Mr. Pearson's decision to make. And so I'm quite certain that
But my point is a little bit different. My
Yeah.
point is that this risk of pressure ulcers isn't from being in the hospital at MedSTAR, Washington Hospital Center. It's a risk from him just being sick and bedridden wherever he is.
no, it's a risk of the facility, the hospital and the doctors not doing what is necessary to prevent it. I understand we're talking about res ipsa loquitur, but with respect singularly to this issue of informed consent, it's whether or not that is the case. Again, a patient has to be informed of the options. And after those, and the hospital may dissuade that patient with respect to those options.
And when you say, your answer was that he should have been informed at the time of his admission, is that because of his particular comorbidities? Is that why you're not saying that a hospital needs to give that information to anyone who's admitted? If I go in today for an appendectomy, do they need to tell me that I might be, I might want to choose a nursing facility instead?
No, because the anticipated stay for appendectomy is probably going to be a day, may not even
Right.
days.
And did they anticipate at the time of his admission that he would be there long-term?
They did anticipate, well, they either knew or should have known, again, because he had end-stage kidney disease, that he had been to that hospital before, treated for similar problems. He had a heart attack, and then they had some concern with respect to whether or not he might have had a stroke.
Okay, so your answer is that given his experience or given his history at the hospital and his comorbidities, they had reason to think his stay would be long-term, and therefore, at the time of admission, they should have advised him that he might be better served in a subacute facility or a nursing facility.
An acute facility generally anticipates a stay of 30 days or less. And so if they're anticipating that he is going to be in the hospital relatively immobile for longer than that period of time, the options to that treatment should be advised.
And
The
does the
patient should be
record
advised.
indicate that they did expect that at the time of his admission?
But what I'm saying is that they should have expected.
Do you
that.
have any expert testimony to support that? Because that sure sounds like something that an expert needs to say.
Well, Your Honor, with respect to informed consent, that can be proven through the defendant's experts. I'm not saying it would be easy, but it can be proven if
Did you-
expert testimony is
Did you,
needed.
in your brief to this court or to the trial court below, point out expert testimony from the defendant's experts that would support this theory of informed consent? That they-
Again,
they-
we are at
that they
summary
could have
judgment.
known.
Again, we were at summary judgment, Your Honor. That would be my argument.
That's not really responsive, right? Because you're at summary judgment at a point where you need to show that you have enough evidence to go to a jury on your informed consent claim. So you need to point to something to say they should have known that he was going to stay in the hospital for a long time, and you need to, have a factual record, of his comorbidities, right? Sounds like you've got that.
Yes, Your Honor.
But then you need expert testimony, I think, to say, based on this, they knew he wasn't leaving anytime soon. And I don't know that you have that, but if you want to point me to that as well, after you sit down while your
we-
colleagues are speaking, I'd be happy to look at it.
We do not argue that it was not in plaintiff's interest to cite to the defendant's experts' reports in arguing a summary judgment motion. The inferences go to the plaintiff. And so we did not seek that opportunity. We didn't get that opportunity to argue much of that in front of this trial court, in front of the trial court judge.
Thank you.
I know
Counsel.
I-
We've kept you up here beyond your time, and I
No problem.
appreciate your stamina.
I
And
appreciate
we will hear now from, I guess it's from Mr. Noggle first. Am I pronouncing your name correctly? Okay, great.
Good morning. May it please the court. Pete Noggle on behalf of MedSTAR Washington Hospital Center. With some trepidation, I'm going to jump right in and say that the abuse of discretion standard is a load-bearing part of this argument, and that the parties are in agreement that with respect to the admissibility of expert testimony, whether that is in the traditional, signing in traditional negligence or in res ipsa loquitur, that it's governed by Rule 702. And that
Why is it load bearing? Why can't we just assume that the expert testimony should have come in and we look at it to see whether or not the plaintiff, whether the Pearsons established on this record that it was more probable than any other theory that negligence was the cause of Mr. Pearson's pressure injuries?
because the basis for the trial court's ruling was that the trial court was not persuaded that the plaintiffs had
I understand what the trial court did.
Finish your sentence. The basis was what?
The trial court was not persuaded that the plaintiffs had demonstrated that their experts' res ipsa theory was more probable than any other theory based on the evidence.
We're here on appeal,
Correct.
and for the purposes of summary judgment, it's de novo review. So whatever the merits or failings of the trial court's ruling on summary judgment are neither here nor there. We look at this afresh, right? And
Well,
why can't we assume that the trial court got it wrong on the expert testimony and look at all the expert testimony that was proffered and say, nonetheless, the plaintiffs that summary judgment was rightly granted to MedStar and Kaiser.
that's certainly one pathway through this.
Okay, I thought you were
Yeah.
saying we couldn't do that.
No. But
Okay.
that is
So-
an avenue through. My point was more.
Why would we want, it just seems, I was very curious about this, why in the briefing we wanted to run through the admissibility of expert testimony, because it seems like the trial court's ruling on the admissibility of expert testimony is absent, largely incoherent. And for there, our review is abuse of discretion. And I really don't understand. I see one statement from the trial court saying, well, the expert's testimony, the Pearson's expert's testimony is shaky. But even if I mean, the court says, even if I consider it, I don't think res ipsa applies here. And so I thought, well, that seems to be the easier way to go here, because I don't think there's a need for a remand unless we need to remand. And if we can say.
We're not going to suggest that a remand.
So why don't we focus on res ipsa then, instead of the admissibility of the expert testimony?
Okay.
So
in navigating that issue, I think that this court's prior decisions in Gubbins and Quinn serve as natural guideposts. I mean, in one, you have a case in which it was held to be applicable. In one, you have a case in which it was held not to be applicable, or the difference could not reliably be drawn. And so the question becomes, which one is this more analogous to? And the central distinction between those two cases is whether or not the record revealed an alternative non-negligent explanation for the injury at issue. Because when the record does reveal that alternative non-negligent explanation, it changes the analysis somewhat. And then there's this burden on the plaintiff to demonstrate that their theory is more probable than any other theory based on the evidence. And unless they do that, the trial court can conclude that inference, or this court can conclude that inference cannot reliably be drawn.
The difficulty that I have with the application of how to apply res ipsa in this case is that it almost seems that you've got to go in steps here. First, you might need to decide whether the experts, whether a jury could believe the plaintiff's expert over the defense expert. I mean, as Judge Easterly has described, I think it's Dr. Osmond's testimony. He says, there were all these reasons why, given the comorbidities that Mr. Pearson had, a pressure ulcer was unavoidable. And the plaintiff's experts say, no, this is the kind of pressure ulcer that is avoidable. It can be avoided, and if it happens, it can be treated, and it doesn't have to arrive at this stage 4 ulcer that we see in the photos. Could a jury just think that the plaintiff's expert is more believable, credit the plaintiff's expert and say, I just don't believe Dr. Osmond for whatever reason, I don't believe him. Then you're left with plaintiff's experts saying, this is the kind of thing that happens only when there's negligence, hence res ipsa, and then res ipsa is off to give us the result that plaintiffs want. So why is that not the right scenario? I guess what I'm struggling with is convince me that what happened with the judge's ruling here was that he usurped the role of the jury in choosing between experts. Convince me that he didn't do that, because I'm worrying about whether that's what he did.
This court's cases have been consistent that res ipsa is a doctrine that should not lightly be invoked in any case, and particularly not in medical malpractice cases, given the nature of the practice of medicine, where you can have these negative outcomes.
But some cases it might apply, but we know that.
It's abstractly it's possible, but that it's the reason that there is this extra attention paid in this context is because you can have bad outcomes. You can have injuries, even with standard of care being provided. And this court's decisions again in Quinn and Gubbins involve assessments by the trial court granted at the instructional stage, but the trial court is still being tasked with making an assessment before it gets to the jury and being asked to assess, does this record, is a jury going to be assessing possibilities or probabilities? Right? Because if there's a lack of medical consensus as to whether or not, as to the cause of the injury, such that it can't be said that negligence is more probable than any other theory, it's just inviting the jury to essentially weigh possibilities and not probabilities. And underpinning all of this is this notion that, at risk of inviting this Rule 702 analysis again, but the preponderance of the evidence standard is underlying all of this, both in terms of establishing the reliability of the testimony and proving causation. And so if you have this doctrine that otherwise relieves you of having to prove breach and causation, but at the same time, the record demonstrates that there's two at least equally plausible explanations, one of which is not negligent, then this court's cases indicate that that's not a situation in which the case should go to the jury under that doctrine. And so it wouldn't be usurping the role of the jury.
I understand what you're saying, but I guess what the plaintiff's position is the defense expert's explanation is not plausible at all. And why isn't a jury entitled to believe our experts when they say this? They, after all, say that they have seen wounds and wounds, endless wounds on patients with all kinds of, I'm assuming they say this, all kinds of comorbidities. Maybe they didn't say that. And I'm telling you, we're telling you, this does not happen. Even when patients are as sick as Mr. Pearson was.
So does they say that? And this, I think, gets just to tie back to what the trial court said. They did say that. But this is,
Did they say that?
Well, so
Even
they-
with people as sick as, even with someone with all of Mr. Pearson's comorbidities, this is avoidable? Did they say
they
that?
didn't say those
They
words.
didn't say that.
No,
No.
they said, in effect, Dr. Guerrero in particular said, all pressure ulcers are preventable, but implicitly
preventable.
to say.
And people come to the hospital when they're sick. But they did not specifically look to the 9 sources of skin vulnerability that Dr. Osmond detailed.
No. No,
And do you think that they were even qualified to respond to that? I mean, they never attempted to,
They-
but had they attempted to, I mean, they aren't internal medicine doctors. Their expertise is only in wound care. So, I mean, why is this a situation of picking between the experts versus just saying their expert testimony is not responsive to the expert testimony that the defendants put forward? The defendants put forward detailed expert testimony as to why someone in Mr. Pearson's condition would have, inevitably developed these sorts of pressure injuries that would have inevitably turned into stage 3 or stage 4 injuries.
Yes, Your Honor. And that's what put this case squarely under Quinn. I mean, it's on all fours in that respect. And those opinions, I mean, those experts weren't deposed. Those opinions haven't been challenged. The reliability hasn't been challenged. So, I mean, it's.
Well, I'm talking, I do want to be careful here because I'm talking solely about Dr. Osmond's report, which went to the trial judge in the summary judgment and motion to exclude experts' papers.
Sure.
The other expert reports, I mean, they were noticed, but I'm not sure that they're properly considered by us because they were not put before the judge in the litigation of the summary judgment and admissibility of experts. Is
Right.
that
And
fair?
That's fair, and they also aren't necessary.
Okay.
Right. So if it's analytically cleaner to just focus on Dr. Osmond, then I think we get to the same place analytically.
Okay.
It does seem that it gets us back to this whole load-bearing question again, because if the plaintiff's expert's testimony comes in, must be because it was reliable enough to come in, and then it is a question for the jury, isn't it? And if the jury believes the plaintiff's experts over Dr. Osmond, if the jury had gotten that, then the case would have been situated in such a way that res ipsa could be applicable. We've now discarded Dr. Osmond. We don't believe anything he said. We don't believe enough of what he said. We believe plaintiff's experts when they tell us that this kind of thing doesn't happen except in the case of negligence. Res ipsa. Analytically, this is just difficult to do. And I just wonder whether we don't get right back to having to assess whether or not the expert testimony was properly excluded.
So in the traditional, when we're talking traditional negligence, where you've got your sort of quintessential duty, breach, causation, and you have experts saying opposite things, that's sort of a familiar credibility jury contest. In the res ipsa locator, it's a bit distinct because, again, it's premised on this notion that I don't know what the breach is. I can't explain the causation, but it couldn't have happened otherwise. And so we have experts who, when the record demonstrates that there are experts on the other side of us saying, well, actually, that's not accurate, that this can happen even when the standard of care is complied with. It's not so much a credibility contest as the jury can no longer reliably infer that it must have been negligence.
The judge has a gatekeeping rule.
That's right.
I mean, that's what our cases have said,
Yes.
right? The judge has to look at these expert reports and say, based on these competing experts, I determine that, you know, the plaintiffs have shown that it's more probable that this injury wouldn't have occurred, but for negligence, or the plaintiffs have not carried that burden. And that's what you're saying, the dichotomy that Quinn and Gubbins
Yes.
illustrate.
That, I mean, that gatekeeping role is a 702 inquiry, and we're not applying that here if we're assuming that the expert testimony came in. Are you saying there's a gatekeeping role at the summary judgment stage as well in the res ipsa context?
Gatekeeping might not
I mean,
be
that's not a great
precisely the
word
right way
for
to
it.
frame it,
Okay.
but it's a preliminary determination.
It's a
suppose.
gatekeeping,
It's
sorry.
less
maybe-
weighing than.
The judge has a role to play to say whether or not res ipsa can go to the jury,
Yes.
right? And it's not just, oh, well, we've got competing experts, and so we let res ipsa go to the jury.
Right.
The judge has to make a preliminary determination. Based on these expert reports, I conclude that it is more probable, right? And that's a legal question, right? So we can review it. And we can assess, it's like a sufficiency question. Do we think that Mr. Pearson or the Pearsons put in sufficient evidence to make it more probable that Mr. Pearson's injuries were the result of negligence, such that this could go to the jury?
Yes.
That's the question.
Yes.
Yeah.
Oh, that you're asking me.
You're agreeing with me. That's the
Yes,
question that we
I'm
have to
agreeing that's the
answer.
question.
And that is the question that I assume that we will grapple with. Do you want to speak, unless there are other questions about res ipsa, or if you have something else that you wanted to say about res ipsa?
It's my intention to focus primarily on res ipsa. I think Mr. Gonzalez is
Going to
prepared
talk
to
about,
address the
okay.
remaining issues. Unless the court has any.
Did you have anything to say about the qualifications of the experts or?
Beyond that they're primarily their wound care experts, not internal medicine. And it frankly wasn't the focus of our motion. So I'll leave that where it lies, I suppose.
Okay.
Yep. Thank you very much.
Thank you.
Morning, Your Honors. My name is Ed Gonzalez. I represent the Kaiser defendants. That's Mid-Atlantic Permanente Medical Group, PC, and Kaiser Foundation Health Plan of the Mid-Atlantic States. Before I address some comments, I do want to respond, I think, to the res ipsa argument to this extent. I think the distinction between the Quinn case and the Gubbins case is very instructive on your question, Your Honor, about whether this becomes a jury question or not. Because you might remember in the Quinn case, there was actually medical authority that gave the expert justification for another probable cause of that. It was a spleen fracture, spleen bleed, or some kind of defect in some kind of surgery that led to hemorrhage. In the Quinn case, there was no such probable cause. There was just an expert who came up to testify that possibly that this could have been an allergic reaction which caused the problem in that particular case. It was an anesthesia case, as I recall, the Gubbins case. So in that case, between the trial judge faced with that prospect of having in Quinn a true issue of what the consensus cause was, whether it was probably caused by something else, did not give that, or it was proper that he did not give that instruction. In the Gubbins case, that the Court of Appeals found that it was appropriate to give the instruction to the jury. But I think there was a huge factual difference in the testimony, the expert testimony in that case, as to what led the trial judge in Gubbins to give that instruction to the jury. So I don't know if that answers your question, Your Honor, but I know you're wrestling with that. But that's my take on those two cases, and I think they're very instructive. The other part of my argument is Kaiser filed a motion for summary judgment And as the trial judge held and stated in his hearing, in his statements, the fatal flaws with the plaintiff's theory against Kaiser is that there has never been any individual Kaiser provider or Kaiser care or any Kaiser the scope of care.
Counsel, do you agree that we don't have to get to that?
We do
question
not.
If
We do not.
we were to determine
We do
that
not.
res ipsa properly did not lie
Right,
here.
and I'll move on. But that was the only additional thing that separates, us from MedStar. On the informed consent claim, and I want to argue that the issue of informed consent, you still need expert testimony to establish that if proper informed consent was given, whatever that consent would have been, and I know we're wrestling with what that consent would have looked like under the circumstances here, but whatever that is, there still needs to be expert testimony under DC law that had informed consent been given, and say, in this case, Mr. Pearson had been transferred to a skilled nursing facility, let's say, whatever the time frame is irrelevant, but whatever that is, that a different result would have occurred. There would have been, and that's pretty clear under the case law. And so
The result, sorry, the different result would be that he wouldn't have been injured, or that he would have, because it sounded like counsel for Mr. Pearson, Mr. Garrow was saying, well, he would have moved would be the different result. He wouldn't have stayed, he would have opted to leave the hospital. Is that the different result, or is the different result that he wouldn't have been injured?
it would not have been injured, that the outcome that occurred here, death, would have been avoided if that informed consent had occurred.
That, sorry, and you just reminded me of another question. I thought, I mean, I had a whole big question about like, well, how do we know that the stage 4 pressure injury led to death? But I sort of tabled that because no one seems to be arguing about that in their briefs. And in the amended complaint, it seems like the Pearsons are arguing not only that the injury was death, but also that it was sort of pain and suffering before death, right? So you just said the injury was death, but should, for purposes of how this has been litigated to date, should we just say that the injury is the stage 4 pressure ulcer?
Agreed. I could broaden my statement to that. Yes, Your Honor.
Okay.
It
And
doesn't
you
have to,
think
it
you're
doesn't have to
saying-
be death. It could be the care, whenever that transfer occurred, that the subsequent care would have improved Mr. Pearson's quality of life, pain, suffering, the expansion of the pressure ulcer, assuming it was a stage 2 or 3 when he was transferred to a stage 4, it would have stopped the progression of that ulcer, that he wouldn't have needed all the life support needs that he needed at the time, that would have, which actually, as Dr. Osmond pointed out, made this an impossible thing to heal. Whether all of those things that Dr. Osmond identifies would have been
Mitigated
prevented
or-
or needed at all
Yeah.
had he been transferred, whenever transfer would have occurred. And so even if you assume that the first part of the informed consent analysis, even if you assume that that consent should have been given, which I don't think there's really enough facts in the record to support that, but even if you assume that, you still have to, a plaintiff still has the burden to prove that that transfer or that consent to do that, whatever that it is, here the transfer, would have prevented some part of the sequela that followed after the non-transfer, if you will. That makes sense. We don't have that in plaintiff's expert designation and in the testimony. There is no such, expert testimony. And I think that's a fatal flaw to the informed consent theory.
You know, I did want to hear whatever your second point was going to be on you were starting to talk about the agency issue and we cut you off, but I would actually like to hear whatever your point was briefly.
Right. On agency, Your Honor, this court has yet to establish apparent authority or ostensible authority as a legal theory. The two cases we cited in our briefs kind of sidestep it. So that hasn't been recognized at all. I think in this particular aspect, well, if this court were to recognize it, the elements of that are a holding out of by a principal, alleged principal of an agent. So here I represent Kaiser. Kaiser would held out the Washington Hospital Center nurses and physicians or other people at Washington Hospital Center. We held them out as our own, as Kaiser's own, as part one, and two, that the plaintiff justifiably relied upon that holding out to their detriment or to their conduct, to conform their conduct to. So that's usually the two elements of apparent agency. In Maryland, where I practice, that's the two steps. Virginia, where I practice, doesn't, like the District of Columbia, doesn't recognize apparent authority. But those are the two elements. And in this particular case, I would argue that even if you were to assume that there was a holding out, which there's no evidence there was a holding out. The evidence is that Mr. Pearson went to the Washington Hospital Center because it was the closest hospital, not because of any other reason. He was admitted to the hospital where he underwent care by scores of providers over the course of 100 days or near 100 days. And there's been there's no testimony that that Kaiser held out any one of those people as its own. People can make certain assumptions, but there's been no testimony that Mr. Pearson, when being treated by a provider or any provider, believed that person to be Kaiser's.
Right, and you were starting to say, but even if you assume there was a holding out,
Well, even if
what?
you were to assume, there has to be some kind of reliance. And so I would say in this particular case, there's no reliance. We have no testimony that there's any reliance on a holding out of the agent.
The whole point of this theory is if there had been a determination that a nurse employed by Washington Hospital Center was negligent, let's say, plaintiffs would intend to hold Kaiser responsible for that under this theory of agency.
That's correct. And that goes back to my initial point. There's been no Kaiser individual identified as caring for the patient, for one. There's been no identification of a hospital person who plaintiff relied upon as being employed by Kaiser. So we have absolutely no evidence to support an apparent agency theory against Kaiser. That's all I have. The other thing I think I wish to comment on, going back to the Res Ipsa argument, is I think the fact that Dr. Guerrero and Ms. Rodriguez both relied upon, as Judge Easterly has noted, this consensus paper and called it authoritative, that in and of itself shows that there are multiple, that there's a probable cause here as to what Mr. Pearson's death was caused by and what led to this pressure ulcer being developed and causing his death. I think if you look at those 9 factors that Dr. Osmond put in his report, and you look at that consensus paper, they map up. And plaintiff's experts have no explanation for that, which is unlike which really puts us in the Quinn camp, if you will, and squarely within the Quinn holding on the Res Ipsa. Thank you, Your Honors.
Thank you, counsel. Mr. Guerrero, we'll give you a few minutes in rebuttal. Sure.
I was attempting to respond to Your Honor's questions in my initial argument. Dr. Guerrero was board certified in wound care management.
Although there isn't there some question about whether it's actually a board certification
I think there's any question.
in his deposition?
It was not. Are you saying that that issue was raised by the defendants?
I'm just saying there was questioning in his deposition as to whether or not it was a board certification. Am I misremembering that?
It is.
It was a type of certification, to be sure.
There were two certifications. One was by his employer, Avora, a wound care management specialist, but then there's American Board of Wound Management, of which he was certified. So two certifications, and I was referring to the former rather than latter. At A302, he spoke specifically about the comorbidities. I just note for the record, he was identified as a patient with multiple comorbidities. Based on that, based on his activity level, his mobility level, contents level, he should have been identified, and all of these preventative measures should have been put in place. And so there was a discussion about comorbidities. I think it went on a bit, but it was discussed.
I just read that testimony as going to the actual negligence theory, right? They're saying, look, he's sort of generally saying he has comorbidities, so you need to have a care plan in place when he comes into the hospital to make sure that he's rotated and given the right mattress and given the right pillow and his heels are suspended and all of these things. I did not see anything where he's actually responding to Dr. Osmond's testimony about being, particularly vulnerable to these pressure injuries because of these comorbidities, and that those vulnerabilities or those comorbidities actually made the pressure injuries inevitable and unhealable.
I don't believe that the defendant specifically asked him about that during the deposition.
Right, but if we're on summary judgment, then you need to have something that responds to the defendant's expert testimony on that point. It's sort of on you to develop that evidence, to put it into issue at this preliminary stage of assessing whether res ipsa applies, no?
Well, Your Honor, I still think, Your Honor, that under the Motorola case, you're asking whether...
Not talking about whether the experts are admissible.
No.
Right, I'm assuming the experts are admissible.
Whether or not there's testimony refuting.
Refuting,
Osmond.
addressing, acknowledging Dr. Osmond's expert testimony, right? My understanding is it's kind of like a burden shifting thing that happens, right? The defendant says we're going res ipsa. The plaintiff says we're going res ipsa, and the defendant says, well, we have these probable alternate causes of this that show that this wasn't likely the product of negligence. And then it falls to the plaintiff to say, no, negligence is the more probable, right? Because I know that that's what the court has to find in order to make this a jury question. And I just don't see that the plaintiff carried that burden here. I mean, I'll look back at the record that you cited to me and see if I see what you said.
Starting at 302 on.
Yep.
And also, by the way, let me just note that in A277, Dr. Guerrero's expert report, he noted that he treats patients similar to patients with problems similar to Mr. Pearson. Your Honor, with respect to that, the plaintiff would still argue if those issues are being addressed under the rubric of res ipsa, the weight question of the testimony is still relevant. And that is an issue that the jury decides. And so while we're not discussing reliability, we are discussing weight, and there's obviously a plethora of cases that talks about the weight of the testimony is to be weighed by the jury.
I guess I'm or I'm not following what you're saying about weight. Because under our case law, the court has this obligation to make a probability assessment. Are you saying that that's the weight assessment?
That is the weight assessment.
Okay, but that is something that the court is supposed to do, and that's a question of law. It's like a sufficiency question, right?
Well, clearly that was not done here. I mean, with respect to.
Be that as it may, we're reviewing a summary judgment determination, and so we get to do it de novo, right? Okay.
You do get to do it de novo. But well, I think the plaintiff has to stand on that. I think you are saying it's an issue. The courts are saying that the probability is a legal issue.
That's what I understand our cases to say.
Yeah. Well, it's more probable than not. But it's an issue of whether or not, after all evidence is heard, whether or not a jury would make a determination. Well, I guess our argument is that.
Gubbins and Quinn are cases where the question was, do you get an instruction on this so that it goes to the jury?
Yes.
Right? And in Quinn, they said, nope, not going to send it to the jury. Court decided, I'm not going to send this to the jury. You haven't shown it more probable than not.
We were in trial at that point,
But what's the difference? I mean, right? I don't know whether a summary judgment motion was made in either of those cases, but it's the same question of, does this go to a jury, right? Like, why would we say, well, you can survive summary judgment, we'll have a full trial, and then say this can't go to the jury under Quinn? So it seems to me it's the same question. Does this go to a jury? It just happens that in this instance, the defendants raised the question of the applicability of res ipsa at the summary judgment stage, as they were entitled to do. And again, the court had this role to make a preliminary determination. We get to make it de novo in reviewing the summary judgment assessment. Correct me if I'm wrong on any points of my law, but that's how I'm understanding the legal framework.
Again, the Quinn case and the other case you cited were in trial after plaintiff had presented plaintiff's evidence. Yeah.
Right. But again,
You go ahead, Your Honor.
why does that matter? If the same objection to res ipsa has been made in the summary judgment stage, saying there's no need for a trial, there's no need to take this to a jury, that's the time for the plaintiffs to put up their evidence to say, actually, we can show that this is more probable.
Well, then our argument would be, Your Honor, we respectfully ask the court to look at the deposition. I'm noticing here on that page more discussions with respect to comorbidities.
We certainly will.
Yes.
Yeah.
Just note as well that I wanted to note that on the issue, and I understand that the other issues are gatekeeping issues, and we don't get to apparent and ostensible agency unless those others are decided. I just wanted to note for the record that Washington MedSTAR Hospital is a Kaiser-approved hospital. In other words, they work collaboratively. If you look at their websites, if you look at the website, Kaiser website, Kaiser says this is a Kaiser-approved hospital where the effort is to provide unified care, a unified agency of care. And so it does make a difference if you are now saying, but you can't tell us which doctor is who did what in this particular case when when the Pearson family does not know who's a doctor, who's a Kaiser doctor, who's a Kaiser MedStar Washington Hospital Center doctor, or vice versa. And what we're saying is, the only point we're making is that there should not be a distinction between MedStar Washington Hospital Center being held liable in this case, and Kaiser Permanente being held liable. They're presenting unified care, and they're doing it under joint control.
And is it just doctors who might work for one or the other? Is it also nurses, or are the nurses all employed by the hospital, for example?
Most of the nurses are MedSTAR Washington Hospital Center. But not all. And the principal doctors taking care of Mr. Pearson were Kaiser doctors, but not all. And given his long stay in the hospital, that became even a more prominent issue. So our argument is that if a Kaiser cannot avoid liability under claiming that there was no parent ostensible agency, we'd also argue on the Hill and Street that we recognize that that has not been decided by this court, but it has not been foreclosed as well. And I think one other final point, it was the defendants that introduced the paper from National Pressure Ulcer Advisory Panel, and not the plaintiffs, notwithstanding our experts who do recognize that panel as one of many authoritative panels. Just wanted to note that
I
distinction.
thought Dr. Guerrero said it was the sole authoritative.
Well, he talked about, I think he mentioned also a CMS. I think he was speaking.
He said it was the sole authoritative source, and then later on he was asked about the CMS documentation, the Medicare and Medicaid, and which he had referenced in his report. And he said, oh, well, he effectively said, I stand by that too. But initially he said that this report, this body was the sole authoritative
I
source.
just wanted to note that he also included CMS as
Okay.
authoritative in this case. Thank you.
Thank you, Mr. Garrow. Thank
you.
you, counsel. We appreciate your time here today. The case will be submitted. Third case on the calendar today is 23 CF SHAKA HALTIWANGER versus United States. I know, counsel, you're still making your way to the front of the room, so take your time, and we appreciate your patience.
Court's indulgence.
I think you've already indulged us, so.
I don't want to miss a thing.
All right, counsel, whenever you're ready.
I'm not sure this is working, but we'll see.
Sorry, I thought you were going to sit down, so that's why I said.
Oh,
that.
no, no,
Yeah,
no.
yeah, okay.
No.
Very good. If you need another minute to get situated.
I
please
never
take
sit
your
down.
time.
You have to make me sit down. Good morning. May it please the court, Mindy Daniels for appellant Shaka Haltiwanger, and I'll reserve 3 minutes for rebuttal. Appellee filed a 28K statement very recently, citing the September 2025 case of Leighton Picone, and that was authored by Judge Shanker. And I'm going to, unless the court directs me otherwise, I'm going to start there and launch into the third argument in the sorry, I haven't spoken to anyone in hours, in the, in appellant's brief.
Do you
In a
have
nut-
water there, counsel? Do you have water? There's some. Oh, okay. Great. Mm.
Thank you. In a nutshell, Leighton, following Supreme Court precedent, held that the government can argue in closing if the defendant testifies that he tailored his testimony, he was present in court, he saw the government's evidence against him. Part of that reason was that it's obvious in any event that he was present and heard the testimony. The prosecutor did that in this case as well, argued that. But that's not the issue raised in this appeal. I think appellee may have filed that statement to say, well, everything is fair game. And we're here to say, despite Leighton, everything is not fair game, and that there should be some guardrails. And I think the Supreme Court even would agree that what's claimed here is that it's erroneous over objection to allow cross-examination of a testifying defendant claiming self-defense about his knowledge of the law. It shifts.
It's error. Why exactly? Because it's not relevant, it's not probative, or what?
Well, it's not reasonable to expect someone with a, well,
Not
any
sure
def-
we've ever had a reasonableness test for admissibility, but are you saying that makes it not relevant?
yes, yes, it's both. It's not reasonable, it's not relevant, it's prejudicial. Most people know that, what's the common knowledge of self-defense? I protected myself. I was afraid for my life. It's irrelevant what a testifying defendant's legal knowledge is of that affirmative defense, his legal scholarship, the intricacies of the law. It's unreasonable and irrelevant to question a defendant about his knowledge of the law and then use that to attack his credibility to sway the jury and disprove self-defense, because it is the government's burden, as we know, to disprove it. What is relevant and the validity of what any self-defense claim hinges on is the subjective belief in imminent danger, whether force was used was reasonable, whether his behavior was reasonable.
So can we look at the fact that, and I'll have some questions for the government about this, but the questioning is, in my view, highly disjointed, extremely confusing. The government's representation of its theory behind the questioning was equally disjointed and confusing. It seems somewhat, I admit it seems somewhat unfair to say this, but can we consider the fact that the disjointed and confusing nature of the questions effectively landed no punches, especially in the context of all of the other factual evidence about the self-defense question here, such that any error here was harmless?
If I understand you correctly, what you're saying is that potentially it landed no punches, that it didn't, that it couldn't have swayed the jury. Is that
Yes.
what the court is asking me?
Yes.
Okay. And I would say that that's not true. First of all, it was allowed in. So the jury knows that they can consider it. It's relevant. And, why wouldn't a juror in the jury room say to another juror, the government's right. The government showed he didn't know anything about self-defense. He got the gun to kill, not to protect himself, like he said. That's a pretty big punch. The other punch is that the implication that the government was trying to make in the questioning was, I mean, we can go over where the government asked the questions specifically, and you'll see that the government's implication is that he didn't get this gun to protect himself. He got this big gun to kill somebody.
Are you saying it's propensity evidence effectively?
I'm sorry, excuse me.
Are you saying effectively it's propensity evidence? Sort of like, here's a person who just arms themselves, and so he is dangerous. And so don't credit his self-defense claim, which really doesn't have anything to do with when or why he got the gun, right? That wouldn't be part of the self-defense inquiry. So it's in the nature of sort of propensity evidence.
Well, there's that too that could have happened in the jury room, especially since the other evidentiary errors that we claim. I mean, I want to stick with this issue, but there was the government was allowed over objection to show that there was a retainer agreement found, a legal retainer agreement found in the car, with his name on it. They didn't need that evidence. They already had his DNA on the gun. I mean, they had 5 different ways to show that that was his gun, that was his car. The title was in the jacket that was left at the scene. His DNA is on the gun.
You're arguing about separate issues here that, I mean, I guess you could make a cumulative error argument at some point. You sort of alluded to that in your brief, but only with respect to the 2 pieces of erroneously admitted, what you claim to be erroneously admitted evidence, not so much the self-defense questioning, but I understand at some level a cumulative error argument, but staying on the issue that you've led with on the questioning about self-defense, if a properly instructed jury, and you haven't challenged the jury instruction on self-defense here, and it seemed correct to me, went back to the jury room to decide whether the facts supported a reasonable, an actual and reasonable belief by Mr. HALTIWANGER that he was in immediate peril of death or serious bodily injury, then what would the questioning and answer about his legal knowledge of self-defense, how would that have swayed their analysis of the facts that related to those elements of self-defense?
Well, you asked about the sway, you mentioned propensity. So I agree with that could have happened. But going back to your question, again, why, if the evidence is relevant, okay, and the jury has, why wouldn't they think it's not relevant?
Well, I mean, but
even though
conflating error with harm, and I'm saying let's assume that it was error.
Mhm.
Why wasn't it harmless?
Well, we're talking about whether or not the judgment could have been substantially swayed by the error. And, the jury can be looking at this 3-page, self-defense jury instruction, right? I mean, even the self-defense jury instruction was very complicated. I mean, if a juror wants to simplify it, right? They could say, well, you know what? We don't have to go through every little thing that happened and all these complicated instructions. He didn't know why not agree with the government's implication, which is what the government implied in the questioning, that how could it be self-defense, or how could he say it was self-defense? Let's put it that way. I mean, because we have to, was it or wasn't it? He's saying it was. Why should we believe him if the government's right and he didn't even know what it was? How do we know that the jury did not consider that in that way? I mean, it's as relevant as any other evidence that came before them. To say that, well, they have the jury instructions, so we don't have to worry about, the error here or whether it was prejudicial. You're saying maybe it didn't punch for you, but there are 12 jurors that it could have very well punched for. And, and again, the implication and even what the government says, why they want it in, right? They say it goes directly to his state of mind at the time. I mean, the government says that's why they want it. That's why they think it's relevant. So why wouldn't a jury consider it for those exact reasons? I mean, in closing argument, the government made the point. They came back to it. So, they tried to, in their own way, hit home that punch. I don't think they dwelled on it because I think that there was a point where the government realized they're getting into error territory.
What exactly did they say in closing?
And I also want to mention the court reason for allowing it was wonky. I can't explain it. Maybe the government can, but I do have that. He said, this whole first they say, this gun's too big for self-defense. Why would you get a gun like that for self-defense? The feeding device. I mean, it was a Glock, but it had a feeding device. Why would you get that for self-defense? Then they add on right after that, and that's a transcript 320, 23 at page 204. Says this whole concept of he never heard of self-defense. He was very comfortable going out and arming himself with a gun. You'll have to believe, or excuse me, you'll have to consider for yourself, if you think it's reasonable that someone who purposely seeks out a gun has absolutely no idea of what the law of self-defense is. So they're trying to make it like he knew what the law of self-defense was, but he didn't do the self-defense. I mean, it is confusing. I agree with you. Even the argument is confusing.
Didn't
But
object, trial counsel didn't object at that point, right? In closing, there was plenty of objection to the line of questioning during cross-examination, but no objection at closing.
That's right. And the reason why I didn't argue plain error, to be honest, is, if the evidence comes in, if it's error for the evidence to come in, then the closing argument is there to show that it wasn't harmless, that they came back to it, that they said to the jury, consider it. Okay. And so that was used for prejudice. If it wasn't error for it to come in, then it's not error for the government to play upon it. So, it really starts with the ability of the cross-examination, and it was over and over again.
Did the trial judge say in overruling objections to the questioning? Because there were objections, right?
Yes.
What did the trial judge say?
The trial judge said, the defense said it's irrelevant, it's prejudice, all that. And I'm on page 54 now of the same transcript, 320-23. He said he got the gun for protection. It's irrelevant. What he knew about the state of the law is irrelevant. What he did, his actions, that's what's relevant, the court says. I'm going to allow it because one of the answers he gave on direct. Go back to that line of question where you asked, why he called Mr. Green and Mr. Taylor from a blocked number. Because he figured Mr. Taylor wouldn't pick up if he knew it was him. Now that answer is just wonky enough, so to speak, because if you shot in self-defense, why wouldn't the father pick up and talk to you? And I discussed that in my brief where I say, I mean, the court's reasoning is a little off. Haltiwanger testified that the reason why he called from a blocked number was he knew he shot the man. He knows it's his son. He wants to know what's going on. He wants to know who this person was. He doesn't even know what happened. So he's going to the father to ask him, and he's going to the other one, Ms. Green. And, he's trying to call them, and he thinks, well, he's not going to answer he knows I shot him. He's not going to answer if he knows it's me. I want him to answer the phone. So I'll call him from a block number. He'll pick up and I'll say, hey, it's me. At least I'll get him to pick up. So the court's reasoning itself is pretty wonky. Maybe the government can explain it better. But I would like to point out where the government keeps going back to it. If it was one time, once, I'd say maybe it didn't have punch. And if the government didn't invite the jury to consider it, okay? But here we are on page, I'm all on the same transcript, 320, on page 56. He says again, he asks him what he knows about the law in DC, twice on page 56. Haltiwanger says, I needed the gun to protect myself. That's what he says. He keeps saying protect himself. He doesn't use the word, I don't think he even uses the word self-defense until the government does. Did you know when you got that gun that the law in DC allows people to defend themselves if they're shot at? He says, say that again. He's confused. Did you know at the time you got the gun that the law in DC allows people to defend themselves if they're shot? No. So it's your testimony, you got the gun in self-defense, but you had no idea you could use it? Objection. Okay. The court says, I'm going to allow that question. Overruled. So jury knows it's relevant. It's overruled. I need to sustain the objection to all of this. Let's go to page 57. It happens again. Okay. He says, okay, so you thought at the time you got this gun, your only options were either committing murder or not using the gun in self-defense. So is it and above that, same page, 57. So is it your testimony that you got this gun to defend yourself, but you had no knowledge that the law allowed you to use it to defend yourself? He answers, I heard about it, but I didn't know about it. No, I didn't know about it. I mean, the bottom line is that even though it was confusing, the confusion affected his credibility because he's confused and he's answering in ways now that, on direct exam, he gave a viable case of self-defense. There was.
And so why again was there error in allowing this? In response to Judge Easterly's question about whether you're saying this was propensity evidence, you didn't seem to grasp onto that right away. What is the error in allowing it? The relevance bar is really low, so I think it's not difficult to fashion some reason why it's relevant. What was the error if it was not propensity?
Well, actually, I was going to argue at the end that I didn't know if I was going to get to all the issues, but I was going to say that the evidentiary errors were cumulative. Let me just get to the other, just take 30 seconds for that. The propensity part, okay, is that, we have a retainer agreement. The defense wanted to say it was just a contract with his name on it. No, it's a retainer agreement, a legal retainer agreement, okay, that the guy has. And then we have this ghost government agent, who gets up there and says, oh, he was reporting to me all the time. And then suddenly he's not. Come on. Everyone, the jury had to know between the two that, he's reporting to this government person and they're not, and this somehow relevant.
Mr. Haltiwanger's own testimony, he said he was a drug dealer. He led with, that was the opening, right? He's a drug dealer. He was there to deal drugs. And I'm not personally saying that makes him a good or bad person, but if to the extent you're arguing that the jury might be led to believe that he had a criminal history, that was established by his own testimony.
Yes, but we're going to a $50 a shot drug dealer. He's small time. He's dealing to these people in the building, single shots. They're going and doing the shots. He's extending $50 credit to a crime wave. Now we have someone who, and he's dealing when he's already in trouble. He's going back to it. We have to stop this guy. He's a bad guy. So there's that. I just want to say there's that prejudice. I didn't get to go through all the times that he raised the the self-defense. I just want to say it goes to page 58 as well, page 63. And here's the thing too. So he gave a very pretty credible story. He was very direct. He sounded like an intelligent guy, on direct exam. So now we're on page 63, 320-63. So, first he says, well, no, and maybe I heard it at the jail. I don't know self-defense. And then the government says to him, I thought you said you weren't even sure that self-defense was a thing. And he answers, now I educated myself more. Now I'm educated on that defense. I mean, to me that he starts sounding very incredible. He went from credible to incredible because he's getting wrapped up in I'll say his own T-shirt. Okay. And that is what the government did here. I mean, if you read it and you see it, you go from saying, wow, this guy's got a point, right? All this stuff happened. It's undisputed. The father tries to stop him. He can't. This guy's got like 4 or 5 times the legal limit, blood alcohol concentration. You hear him say, I'm going to excuse my language, I'm going to drag your ass. A second later, a shot is heard. I mean, he has a viable self-defense claim. And now on cross-examination, and here's the prejudice, I'm trying to answer your question. Now he sounds unbelievable. His credibility has been affected. And that's
My
the
question is,
punch.
where's the error? Because I see where you're going with prejudice, but the most relevant evidence is really prejudicial. I saw him do it. What can be more prejudicial than that? So prejudice is not enough. What was the error?
What was the error in allowing this?
Yeah.
I am saying to the court that this is not appropriate in any case to ask a testifying defendant, and let's stick with self-defense, to ask them, what is your knowledge of the law? If the court affirms this, that tells the government, when you have a testifying defendant testifying about self-defense, you can ask them, about their knowledge of the law, unless, we can go, to this exception, that exception.
Seems like I could think of cases where one might think that you could ask, in any number of white collar cases, you could ask someone, what was your knowledge of the law, right? What seems different in this case is that the questioning is focused at a different time than, right? He's not disputing that he had the gun. So that's just it's not a disputed question. And the disputed question is whether he acted in self-defense. But these questions are not asking about his state of mind at the time he allegedly acted in self-defense. These questions are focused about to the time when he purchased the gun, which I have no idea why that's relevant, right? The question is, did you know at the time you got the gun that the law in DC allows people to defend themselves? Did you know at the time that you got the gun in the law in DC? Same question, right? So it's your testimony that you got the gun in self-defense. I mean, I conceivably could, purchase an Uzi because I want to shoot up my neighbor's, birds or whatever in their backyard. But then when somebody tries to break into my house, I use it in self-defense. I don't know what I knew about the law of self-defense, or what I knew about whether or not I could buy an Uzi, or whether I knew that I could shoot birds has anything to do with whether I'm legitimately acting in self-defense at the time when self-defense becomes an issue, right? The test for self-defense is whether or not at the time that you are acting in self-defense, you think that you're in imminent danger of death if you're using lethal force. So asking about his knowledge about what he knew about self-defense at the time he bought the gun seems to have nothing to do with anything, completely irrelevant.
Your Honor, I'd like to redirect you to what the government said to begin with on page 53, where he says his knowledge of the law is self-defense and whether he's allowed to defend himself legally goes directly to his state of mind at the time he did the shooting.
That's what
And
they
I
say
think
to the
that-
court, but the questions that the government is asking about what were you thinking about the time that you bought the gun?
I think a
And
fair.
one could have a completely, culpable mens rea at the time that you buy the gun to intend to do an illegal act with the gun. But I don't think that that defeats one's right to exercise self-defense if and when a true self-defense situation arises.
I think if you go through the entire cross-examination, that it's more than just about the gun. I think a fair reading of it is, it's not just about when he got the gun. It's about his use of the gun as well.
You know, as I read it.
And I would request that the court read the cross-examination carefully and again, because it's not my impression in my argument in my brief was that it wasn't just about the gun. I don't want to take up the court's time by rereading, the entire cross-examination. The court can do it on its own, but I would disagree with you that it was only about the gun, the implications of it, the timing of the questions, when they're asked. And then at other points, the government says, oh, well, I'll abandon this line of questioning for now. I mean, that was all part of it. I mean, this is all planned. There are no accidents here. The government's intent was to show his state of mind at the time he did the shooting. I don't think they abandoned that in their cross-examination.
I think you're over time, but I think Judge Thompson had a question.
We're over time. I won't pursue it. I was only going to say that it seems to me when you look at the entire testimony, I have no idea what the intent of the questioning was, but it's not hard to imagine for me what the intent was. I mean, we have this testimony about not checking in with the government employee that he was supposed to check in, and the theory that that probably was because of consciousness of guilt. But if you're someone who claims you acted in self-defense and you knew way back when you got this gun that there was a law of self-defense, maybe you wouldn't have avoided checking in with the government employee, or maybe you wouldn't have felt the need to block your identity on a phone call. It seems to me it all tied together, so it seemed relevant. That's why I'm searching for what the error was, because I don't know if this was the prosecutor's reason for the questions, but it's not hard to imagine that that could have been a reason. But that was probably not worth taking us over time.
Your Honor, if
So
I'm
we can move on.
interpreting, if I could just answer what you said. And I'm not sure that I'm interpreting what you said correctly, but if you're saying that the questions were relevant, in a self-defense case, well, the government has to disprove it, okay? He doesn't have to prove it. So, and I do want to say that the other prejudice here is burden shifting. He's asking the questions and saying, basically saying to him, well, prove that you acted in self-defense from the get-go, from getting the gun, prove you acted in self-defense. It begins with that. It begins with getting the gun. Why did he get the gun? For protection? No, he's a killer. Okay, and I think that that's a big point to make. And what's relevant is the belief in imminent danger, all those other things, and it just blurs that. It just blurs it. Thank you.
Okay, Ms. Daniels, we'll let you sit down. We'll give you a few minutes in rebuttal.
And good afternoon. I was checking to see if it was morning or afternoon. Good afternoon, Your Honors. Brian Hahn for Pelley, the United States. I'll start with the self-defense cross-examination issue, since that's what was spoken about most. I don't think the trial court here abused its discretion by allowing that cross-examination. And I did appreciate, Judge Thompson, you going through the exercise of talking about what you were thinking, because I think there are two reasons why this was, at least this where this defendant's knowledge of self-defense was relevant. And first, it's because of the consciousness of guilt that you were talking about, Your Honor. That is, there are actions that he takes afterwards, and primarily this calling from a blocked number. I think it's 16 times he calls Keith Taylor or Vanessa Green the day of the shooting, and then 8 times he calls Vanessa Green the day before her grand jury testimony. And that shows his consciousness of guilt. And whether or not he thinks that he shot someone legally or not in self-defense
And all
reflects
that-
upon that.
Sure, and all of that seems totally legitimate. But as my questions indicated earlier, what seems odd to me about this line of questioning from the government is that they're not asking about his state of mind after the fact. They're talking about his state of mind before, like well before. I can't remember when he says, I mean, he says he got the gun after the 3rd time he got shot. And I don't know when that was relative to this incident, but sometime before. And I just don't know why, as a legal matter, that is relevant to his consciousness of guilt, to his exercise of self-defense. I mean, he's a drug dealer. He bought a gun. He presumably bought it for an illegal purpose. But it seems to me, again, like one could have a totally culpable purpose in buying a gun at the time one buys it and still legitimately use it in self-defense at some future point if the self-defense test is satisfied. Does the government disagree with that?
I don't disagree with that, Your Honor.
Okay.
I think that they can buy the gun intending and using it illegally.
I
Maybe there are
intend
other
to
crimes.
use the gun to kill my, partner.
Yeah, certainly, maybe
But
there are
then
other.
it happens that somebody breaks into my house before I'm able to commit that act, and I use the gun in self-defense. That's okay, right? So I'm not understanding why these questions that are all very focused on what he knew at the time he bought the gun have anything to do with this case. And I take your point about his consciousness of guilt, the consciousness of guilt evidence afterwards, but that's not what this is. This is like pre-consciousness of guilt. And I'm not aware that there's any cases that, this isn't a premeditated crime. It's a self-defense case.
So I think that, certainly it might have been more probative for him to ask about later periods in time. But I think that it is, in fact, probative if appellant knows about self-defense earlier in time. That suggests that he knows about it later.
Still
in
know
time
at
as well.
the time he was not checking in with the government
Yeah,
employee?
I think that if he knows about it earlier, that is probative, and maybe not that probative, but is probative of whether or not he knows it later as well. I take your point, Your Honor, that it's not, straight
At best,
right down the
it's
line, but.
minimally probative. I'm still not quite getting what it is probative of. What do you think it's probative of?
I think that if I know that the sun rises in the east, if I learned that 10 months ago, it
Let's stick with-
establishes that I know that
guns.
I know it now.
That's too abstract for me. Let's stick with guns. Like,
Sure.
I know that it's illegal to have a gun, and I buy one. Why is that relevant to my self-defense claim?
So
Whether I have consciousness of guilt after I kill someone and I'm alleging that I did it in self-defense?
So knowledge of self-defense, right? I think we've sort of discussed this for the consciousness of guilt argument, is that if you know that you did something that was legal, you're less likely to act in a way that reflects consciousness of guilt. And if he knows far previous to the time that the murder happens about the law of self-defense, that suggests that he did know about the law of self-defense at the time that he committed the shooting.
And at the time, he refused to check in with the government agent.
And after
I
the
don't
shooting.
need to hide because I knew the law of self-defense just like I did when I bought the gun. I still knew it after the shooting happened, so I didn't need to not call the government employee, and I didn't need to block my phone calls because I was fully justified in what I did and I knew it.
Do you-
I knew the law.
Support this sort of anticipatory consciousness of guilt argument?
I don't. It's just
I just
sort
have
of what's
never
not.
seen this, and it seems to really open a can of worms.
I mean, I sort of think I understand that, it is more directly probative to ask about his knowledge of self-defense closer in time. And I think that this sort of goes to Judge Schenker's point about the punches not hitting, is that what happens here is that appellant says, I didn't know about it at the time. And so, I mean, that sort of undercuts what the prosecutor's argument was about this, right? If he doesn't know about the law of self-defense, then he thought he might have done something wrong, and therefore he acted in a manner that showed consciousness of guilt. That actually worked, I think, to appellant's benefit in this case, actually. Because if appellant doesn't know about self-defense, then of course he's going to act like he did something wrong because he thought he did. But now that he knows about self-defense, he can claim it at trial, and that if that is in fact the facts lined up with that.
But so was it the government's theory that then undermined his factual claim of self-defense?
I don't think so, Your Honor. I don't think that there was anything, the government didn't argue anything about how his knowledge of self-defense undercut his factual claim of self-defense. That wasn't argued in closing. That wasn't suggested
But
by
isn't
the
that the
questions.
point of arguing consciousness of guilt?
I think that's the point of arguing consciousness of guilt. I think that appellant's answers in this case didn't support that argument very well. And I think it
Unless
was,
the government comes back to it in closing.
yeah, I think the government says you can consider that testimony and see whether or not it's credible. I think that in closing argument, attorneys can say that about really anything that a witness says. And that's part
It
of,
just suggests that the government thought that it actually hit.
I don't know that it's just the government thought it hit. I think maybe the prosecutor didn't find him credible when he said he didn't know about the law of self-defense. And maybe that's why he said that during closing. But I don't think that means that certainly that this affected certainly affected this case. I think that, as Judge Schenker pointed out, the jury was properly instructed as to the elements of self-defense, which had nothing to do with whether or not appellant knew about the law of self-defense. And there was a lot of, appellant's story was contradicted both by Vanessa Green's testimony that he shot Anthony Kelly in the back. I understand there was impeachment for that, but her testimony was corroborated by the physical evidence, and appellant's story was not. Appellant was shot in the back. The medical examiner testified to that based on the entrance and exit wounds and what they looked like, and the rib fracture that was outward instead of inward, which demonstrated that the bullet came through the back and out the chest. There was the DNA analysis didn't show any of Anthony Kelly's DNA on appellant's jacket, which showed that his testimony about Anthony Kelly grabbing him from behind was less likely. And of course, the medical examiner said that she didn't find any stippling or soot on Anthony Kelly's clothing or body. And so it was unlikely that the shot came from, I think she used the term close range, but within 3 feet. And appellant's, of course, testimony was that he turned and shot Anthony Kelly sort of immediately after he was being grabbed at close range. So I think that certainly, even assuming that there was error in this case, allowing this cross-examination, and I do agree, Judge Schenker, I think the questioning is a little bit confusing. I think the answers are a little bit confusing, but I don't know that that's error. I think that it's perhaps inartful, but not error. But even if it was error, I think that certainly in this case, it was harmless as to the contested issue of self-defense.
Can I ask you about the evidence of the legal retainer agreement?
Of course.
Let's say we can connect the dots that the government was trying to connect between, the difference between a contract and a legal retainer agreement, and whether the latter bore more on Mr. Haltiwanger's control of the car. Let's back up and ask what his control or even ownership of the car how that had any relevance to the issues here. Mr. Haltiwanger stashed a gun on a car tire and fled the scene. Maybe I'm just missing something, but I don't understand what difference it makes whose car that was.
I think it matters because I think it's more likely that someone would stash a weapon or something like that in the wheel well of their own car than
We
someone
know-
else's.
Yeah, but we already know it's undisputed that he stashed the gun.
Sure, and I think that, I mean, it is undisputed at the time he testifies, I guess. But, and I know the defense does open on a theory of self-defense. But I think that still the government does have to prove every element of the offense beyond a reasonable doubt and tell the story of what happened and show that the government did its homework in investigating and prosecuting a case. And
When
so,
does this come in?
sorry?
When does the legal contract come into evidence?
The legal contract comes into evidence during the government's case. It is in the, I don't know exactly when, but I believe there is testimony about somebody, they have towed the car and they are, they're going through it as part of the investigation.
It's before Mr. Haltwanger testifies, it was my car.
That's correct. It is, yes.
And sorry, you were then saying, and I cut you off, I apologize, that the government has to prove every element. And why is it that they have to show that it's his car?
Again, it is more probative that he would have stashed the gun in the wheel well of his own car. I mean, perhaps
Why
because
do
he
we,
can,
why do we care?
because we have to prove that he's the one that was there.
We had this magazine charge too, right?
He has the
And-
magazine charge as well, and he has the
And was
possession
it
charge.
attached to the gun? I don't know much about guns, but I mean, didn't they have to show possession of that?
My memory
Am I
is that
confused on this point?
my memory is that when they actually find it, it has become detached from the gun. I think it's too big to like stash by itself. I think he takes it out. But I am
It's not stashed in the car with the gun. Yeah, my thought was that it was in order to prove possession of that.
My memory is that they find the gun in the wheel well, and then when the car moves, they find the magazine under it. When they move the car, they find the magazine under it. And so I think it would go to that. Of course, I don't know if the court noticed, the government did file a letter saying that we were not opposing vacatur of that conviction.
Right, but I mean, my point was, at the time, the government was putting on its proof.
That's right.
My
That's right.
thought was that they needed to show possession of that. And maybe they didn't if it wasn't in the car, maybe it was under, but it does seem that you'd be more likely to stash something like that in your own car.
That's right.
Under your own car.
And I don't know that there is a good description of the magazine or the gun from any of the witnesses. I mean, only Vanessa Green, I think, sees the actual shooting. Most of the other witnesses only hear it and sort of its aftermath.
But so, I mean, we started to focus on the issue that perhaps the government didn't know that Mr. Haltwanger was going to cop to ownership of the car because he hadn't testified yet. But in the pretrial motion in limine proceedings, Mr. Haltwanger offered to stipulate to ownership of the car. And the government rightly argued below that under Old Chief, it's not required to do that. But it does seem like an awful stretch to say, no, we have to put in this legal retainer agreement and not just call it a contract, but call it a legal retainer agreement, as opposed to if the point is this was his car, why not just stipulate at that point? And maybe your answer again is just Old Chief, but.
I think part of my answer is Old Chief, of course. The government is not required to stipulate. I think that.
Chief just says that the government's allowed to put in, sort of the details of its case that are necessary. And it just seems like, why is the fact that it's a legal retainer agreement as opposed to just a legal document with his name on it, right? Like, I mean, a document showing that it's his car. I mean, I don't know. There are just a zillion ways that one could have sanitized it better. And it just seems like the government is trying to get something under the auspices of Old Chief that maybe it shouldn't have.
So I don't think Old Chief says, it doesn't say necessary, right? I think it says that there's a lot of ancillary things to strictly the elements of the offense.
Yeah, but I mean, that's what I'm getting to is sort of like, what's ancillary here? It just, other than sort of showing this is a guy who needs a lawyer on retainer, which seems highly prejudicial.
I mean, it's a question of abuse of discretion, right? And what the trial court here says, agreeing with the government, is that the fact that it's a legal retainer agreement has more probative value than it just being a legal document, that a legal retainer agreement is a more personal item than a contract, and that it sort of outweighs the unfair prejudice. I think, I don't remember who pointed it out, but
I mean,
you
it
know,
depends on the nature of the contract, right? Like certain contracts could be quite intimate and sensitive, but others not so much. And so, the jury could, I'm not sure how far that gets you.
sure. I mean, if it were a sensitive legal contract of a more sensitive nature, that would have
Arguably-
other probative value, sure. But again, I don't know that it's an abuse of discretion for the trial court to have balanced that versus the unfair prejudice here, which, the court said, look, it's sort of a wide leap to assume, maybe I'm switching my issues, but I think the trial court determined that it wasn't, like, the jury's not going to jump to, well, he has legal troubles criminally. And if it did, and again, I don't remember who said it, but the jury knows that appellant's a drug dealer. He came, the story from Keith Taylor and Vanessa Green is that he comes to the apartment to sell them drugs. And so if the jury is going to think anything about legal troubles, it's going to be that.
But is that all?
That's not.
Is that all the more reason to be very careful about how this testimony comes in, right? I mean, the jury is going to know that he's a drug dealer. Like, maybe we shouldn't be talking about legal retainer agreements.
And
Could have been a divorce lawyer, could have been any kind of legal retainer agreement.
it could have, and I think it wasn't said to the jury what it was. And again, I think the prejudice is fairly minimal. And I will also say, and we talked about sort of the combined prejudice argument. I think that even if we take all of these and assume that they're error, the self-defense cross-examination, the admission of the retainer agreement, the admission of the check-in evidence, I think that the strong, overwhelming evidence that appellant did not, in fact, shoot Anthony Kelly in self-defense and instead shot him in the back when he was not under threat of imminent serious bodily injury was overwhelming, such that even assuming that these were errors, it was harmless. And if there are no further questions, we'd ask the court to affirm the convictions other than the large capacity ammunition shooting device. Thank you.
Thank you very much, Mr. Hahn. Ms. Daniels, we'll give you just a few minutes.
Yes, thank you. First of all, when you have that retainer agreement and the reporting to this ghost government agent, that's not divorce. I mean, I think that it becomes pretty clear that it's a criminal matter. Also, I want to make the point that the retainer agreement came in at transcript 39148 to 49, and that was after they've already proven the title to the car is in his jacket found on the scene. The keys found in the jacket opened the door to the Infinity. His DNA was found on the gun in the wheel well. There's a prescription receipt with his name on it in the car. Someone named Ms. Hackett testified she saw an African-American man with a limp. Not everybody has that. Walking, stopping at the Infinity and placed something underneath it. And that the 4 cartridge casings from the car that were in the car all came from the same type of gun. That was all of it before the retainer agreement came in. The government made a point about there was no DNA found on the jacket. There was no DNA found in his Infinity either, and that was his car. So I don't think that, the fact that there was no DNA found on the jacket is a big deal. I'd like to go back quickly, though, to the issue of if the court affirms this and says, okay, there's error, but we don't think it arises to enough prejudice to reverse, that will change the entire law of self-defense and the government's burden to disprove it, because that is burden shifting when you're asking someone with a high school diploma, what their knowledge is of the law of self-defense to disprove it. I mean, the court needs to see that the point of it all was to disprove self-defense. And it changes everything if the green light is here. Then the government can do it in every case and just hope that it doesn't rise to prejudicial error. I know that the court constrains itself. This is a homicide case. You don't like to reverse homicide cases, but This was not fair, and he deserves a new trial. I just want to end with the government made a point about, well, he was shot in the back. First of all, the medical examiner didn't say that she could say that he actually walked up to him, shot him in the back. The evidence at trial was not exactly overwhelming. Ms. Green testified that she saw him turn, which means he was in front of him, which HALTIWANGER testified. It was consistent with what he testified, and shot, and that he blindly shot. Okay, this guy's drunk, they're tussling, the position of the tussle, the breakup of the tussle. It's not unimaginable that this, drunk guy, that his back gets turned. He said he blindly shot. That was his testimony. So, there's that part of it. And I want to say something else. That it's not dispositive. The other thing too is that there are people coming down the stairs behind them trying to see what's going on. I mean, certainly Mr. Kelly could have been distracted by that as HALTIWANGER turns to shoot. I mean, it doesn't really make sense that this man is relentless pursuing him, and suddenly he's going to be in front of the guy instead of still behind the guy, making sure he gets him out. He even pushed his father away so he could keep attacking him. I'll end with that, and I'll just say, that the court should conclude for a number of reasons and cumulatively that, if he's not entitled to just a reversal of his convictions, that he is entitled to a new trial. And again, affirming here it just changes the whole already intricate law of self-defense to now put in this ingredient that you can grill a defendant on their knowledge of the law of self-defense when they obtained the gun, when they shot. And again, the cross-examination goes beyond just obtaining the gun. It was what it was going to be used for as well. And thank you.
Thank you, Ms. Daniels. Thank you again, Mr. Hahn. The case will be submitted. We appreciate your time and patience today.
Thank you.